Hi, Dr. Egor. Greetings from Brazil. I can't hear you.
Hello everyone. We
Oh,
just
yes.
wait 3 minutes, three
Yes,
minutes more,
yes,
and we will start.
yes. Greetings from Brazil. Dobry din. Очень приятно.
Sorry, some technical issues because we have at the same time the translation in YouTube, and yes. Dear professor, we can't hear you. Your microphone is turned off.
Yes. How are you? How are Dr. Igor? How are you, Dr. Dilton? And all, how are you from Jordanian, Prof. Dr. Abdul Wahab?
Yeah, thank you very much for connecting. We all very happy to see you here today. It is Professor Karedina, and I will introduce in a little time.
تكلمي لي عنه.
I think we can start. I will introduce, dear colleagues, dear friends. It's my great honor to open the international section of the second Jans Forum Insolvency, Bankruptcy, New Problems and Challenges, organized by the Law School of Lomonosov Moscow State University. Today, I have the pleasure to give the floor to Professor Svetlana Alexandrovna Karelina, Doctor of Law, Professor of the Department of Business Law, and Head of the Master's Program, Legal Regulation of Insolvency Bankruptcy at the Law School of Lomonosov Moscow State University.
Уважаемые коллеги, дорогие друзья, мы искренне рады приветствовать всех участников нашей конференции.
Dear colleagues, dear friends, we are sincerely pleased to welcome all participants of our conference.
Мы благодарим вас за участие и за то, что вы присоединились к нам из разных стран. Для нас особенно ценно видеть такую широкую географию участников.
We would like to thank you for your participation and for joining us from different countries. It is especially important for us to see such a wide international geography.
Позвольте отметить, что для нас важно не то, что это уже второй по счету форум по банкротству молодежный, а то качество и интерес, который он вызывает.
I would like to note that for us, it is not about this being the second forum, but about the quality and the strong interest it has received.
В этом году мы получили более 150 заявок на участие, что свидетельствует о высокой актуальности выбранной тематики и значительном интересе к проблемам несостоятельности.
This year, we received more than 150 applications, which shows the high relevance of this topic and the strong interest in insolvency issues.
Сегодня на юридическом факультете Московского университета уже состоялось пленарное заседание, и далее работа форума продолжится в рамках 5 секций.
Today, the plenary section offline here in Moscow has already taken place, and now the forum will continue its work within 5 parallel sections.
Особо хотела бы отметить, что международная секция проводится в этом году впервые, и для нас это важный шаг в развитии форума.
I would also like to highlight that the international section is being held for the first time, and this is an important step in the development of our forum.
Отдельно хотела бы подчеркнуть, что у нас есть значительный опыт организации научных мероприятий, в том числе крупных международных. Однако особенность данного форума заключается в том, что он организован молодыми учеными для молодых ученых, студентами и аспирантами для студентов и аспирантов, что делает его особенно ценным с точки зрения академического развития и формирования международного научного сообщества.
I would also like to emphasize that we have extensive experience in organizing academic events, including large international conferences. However, the unique feature of this forum is that it is organized by young scholars for young scholars, by students and PhD candidates for students and PhD candidates. At the same time, the organization is carried out under the careful and professional guidance of senior colleagues, which allow us to combine a high academic level with the initiative of young academic community, which make it especially valuable for academic development and for building a scientific community.
Модератором данной секции выступает Егор Кузнецов, мой аспирант, который также активно принимал участие в ее организации.
This section will be moderated by Yegor Kuznetsov, me, who has also been actively involved in its organization.
Мы надеемся, дорогие коллеги, что сегодняшняя работа будет содержательной, интересной и приведет к новым научным и профессиональным контактам.
We hope that today's discussion will be meaningful, engaging, and will lead to new academic and professional connections.
Отдельно хотела бы отметить, что после завершения форума всем участникам будет направлена информация о возможности публикации статей.
I would also like to note that after the forum, all participants will receive information regarding the possibility of publishing their articles.
При этом сразу хотела бы подчеркнуть, что, к сожалению, мы не сможем опубликовать все материалы, несмотря на наш интерес к каждой работе. Просим вас отнестись с пониманием к этому вопросу. По всем вопросам, связанным с публикацией, вы можете обращаться к Егору Кузнецову.
At the same time, I would like to emphasize that unfortunately, we will not be able to publish all submissions despite our interest in each work. We kindly ask for your understanding in this regard. For all questions related to publication, you may connect with me.
Уважаемые коллеги, желаю всем участникам продуктивной работы и интересных дискуссий и благодарю за внимание.
I wish all participants a productive session and engaging discussion. Thank you for your attention. Thank you very much, Professor Karachina. And today we are pleased to bring together a truly international group of speakers in this section, and we have participants from a wide range of countries. The structure of the session follows the program you received, and due to time zone difference, we have made certain adjustments, and we truly appreciate your flexibility and understanding. Also, I would like to underline the important help of our usual friends of faculty, Jorge Sac Torres Manrique, Delton Ribeiro Brazil, Fabio Farinella, and we also waiting that after this conference we will have much more friends which will participate in our conference in the basis forum. Thank you very much, and I think now we will proceed with our program.
Да, вы скажите, что я пойду дальше модерировать секцию.
Svetlana Alexandrovna at the same time has another section which she moderate, and we will continue with our section in the smaller group.
Да, ну, скажите, что я присоединюсь еще попозже.
And Svetlana will come back later.
Всего доброго.
The first speaker of our conference Sorry if I pronounce it wrongly. Professor Dr. Abdul Wahab Al Mamari, PhD in Legal Studies, Israel University from Jordan. We give you the word.
Thank you, thank you. Uh, uh, Share for my present.
Yes, and try again.
Yes.
Thank you.
Thank you, ladies and gentlemen. STEMID College, dear friends from around the world. It is a great honor and pleasure for me to participate in this ancient scientific event, which bring together a remarkable group of researchers and experts, reflecting the spirit of international collaboration and knowledge exchange. On the oceans, I would like express my sincere gratitude and appreciations to the organization body, especially Moscow State University for their outstanding efforts in around this valuable scientific greeting. I would also like to extend my special thanks for Professor Igor for this support and decisions contributors, as well as Dr. Ishaq, Dr. Delton, and all college and friends from the participants countries, whose experts and ensures enhance this event. Such a scientific meeting provide available opportunity statement, academic dialogue, build bridge of collaboration and exchange ideas that contribute to the advancement of scientific research and the sphere humanity. I wish this event very such success and all participants further decision and manifold scientific outcomes. Thank you. Now, my paper about the effects of insolvency on commercial activity. Uh, Content this paper. Number one, first, contracts in respects of which insolvency is declared before their performance is completed. Second, contracts of sale. Third, lease contracts. Fourth, employment contracts. Fifth, administrative contracts, license and concession rights. Introduction. Uh, Individuals and business enter may contract financial research in the courses of this commercial activity, potentially leading to insolvency, such as the series of debt payment or sessions, where liability exceed assets. Such circumstances adversely affect and the delections of insolvency gives rise to legal constituency affecting the debtors contract and dispositions creating. Section 1, an important question is there given that argument enters into various commercial contracts. If the merchant experience financial deserts that prevent them from voling. Contractual obligational and debits and is subsequently the shares. This issue will be examined by analyzing these contracts according to their different types as follows. First, contracts in respect of which insolvency is declared before the performance is completed. This contract was concluded prior to their election of insolvency and the barriers had already been their performance. However, insolvency was declared before their completions. The effects of such contracts and not limited to the debitor and creditor alone, but also extend to their third betters who are connected to the merchant through this agreement. As stipulated by the insolvency law in Jordanian, number one, the insolvency trustee of the debitor under the supervision of the insolvency trustee as the case may continue the performance of ongoing contract and may require the other party of fully performance it is obligations. Number two, the other party may request the insolvency trustee or the debitor under the supervision of the insolvency trustee to make a decision requiring the intention to continue to performance of the contract within 5 days from the date of notifications of the request. Otherwise, the right to the social ladies. This is Article number 27B of the insolvency law in Jordanian. Termination of ongoing contracts. Termination surface the interest of insolvency recording The insolvency authority or debitor under supervision may terminate contract. Okay. Second, contract of sale. The contract conductivity merchant barrier to the delections of insolvency are differs. They may include a contract of sale, construction contract, lease agreement, and other as required by the nature of commercial activity through which the merchant seeks to operate their business and achieve profiles and interest. Third, lease contract. Lease contract are charted as time-based agreement, meaning there are preferred over a period of time. Fourth, employment contracts. Employment contracts with regard to employment contract, the law while taking into account all parties insolvency in the event of the debitor insolvency also considered, and the protection of employees accordingly it provide that other this. Fifth, and administrative contracts, license, and concession right. Administrative contract, license, and concession right holder particular employment for the debitor. Therefore, their medical terminal may case scientific harm accordingly the insolvency law provides and other this. Okay, effect of the declaration of insolvency transaction barrier to the deletion of insolvency. Look at the effects. Okay. Okay. Suspicions of economic activity. Suspicion of economic activity. One of the most important effect of insolvency. Thank you.
Thank you very much. It was very interesting, and to be honest, it is our first time with you in our conference, and we will glad to see you in our next conferences. And now, there have been some minor adjustments to the program, including one anticipated change. Two speakers, Dr. Vivek Kumar and Dr. Jorge Sac Torres Manrique, have exchanged their time slot. And now I am pleased to welcome to Dr. Vivek Kumar, Associated Professor of Law at Institute of Legal Studies, India. We give you a word.
Very good morning to all the dignitaries. First of all, I would like to say thank you, Professor Eger. Professor Abdullah, for his valuable and considerable lecture on the very relevant concerns. I also say my greetings to Professor Dalton Rivera from Brazil, my elder brother, part of this great event. The prestigious university, the State University of Moscow, having the faculty of law, very aptly selected the topic relating to the challenges before the world regarding insolvency and its laws. As an academician, when we go through the globe, I would like to say certain things that it is not an impartial research or research based on certain biases, which is based on the northern globes or northern world's approaches towards the insolvency laws and its development. As we go through the documents, fundamentally we find two notable documents or states which carries an insolvency laws development around the globe. One is Chapter 11 of United States of America, which deals about policy, and another is EU directives, which deals about the insolvency laws or insolvency. First of all, I would like to connect with the biases. Biases I would use. My topic for today's presentation is challenging global north biases, a reverse lessons from global south, insolvency, innovations for worldwide reforms. This is in fact that certain countries, or specifically to whom we designate as in developing or least developed countries, they try to copy or they try to transplant the developed nations' policies and laws without going to the adaptability and their applicability, without going to understand that adaptability and applicability of those laws. They are in an impression that being they are in developed countries, if they adopt those laws, they also become developed. But it is an illusion, because one thing that those laws which is applicable in those locations or those countries are not efficient enough to deal the concerns. Likewise, the most prominent legislation which is about to be accepted and have an impact around the globe is Chapter 11 of US, in which it is also a cause of lengthy litigation of insolvency, and it sometimes it creates an hurdle in the development of business, because business is the term which is about to regulate the global scenario of the development. If it is hampered and it is specifically have some lacunas, another thing is the we can say the preventive restructuring directives of European Union, which is also not efficient, or we can say that suffers chronic efficiencies. French safeguard proceedings has also creates an stagnatic state of the insolvent. German schemes lack cram down powers. Netherlands face court backlogs. To whom we are going to adopt, they are also suffering certain lacunas. We can say that no northern model is universal or superior in the terms, but today's, as I talking about, I am concerned about the development or lessons, or we can say the converse of global scenario, or we can say that the global south is creating a marvelous or work in the insolvency litigations or insolvency resolutions, we have certain specific examples due to allocation of time. I just quote the autochthonous approaches of global south. Most importantly, I have to consider the promotion of workouts adopted by Malaysia, Philippines, and Thailand. Likewise, in the same line, where it is specifically out of court settlement, it avoid the stigmatic affair of the concern. It creates a less expensive and a speedy process for the resolution of the dispute, and it make momentum to the business. Likewise, this approach is also considered by British, or we can say where a London bank provide incentives to out of court settlements or legal workouts, and which is very popular in these terms of in area of insolvency by the name of London approaches. In specification, the Australia and European countries are very least concerned with workouts, or they are we can say the reluctant to accept this type of litigations, or I am just supposed to say that Australia discouraged the workouts. Uh, the norms in certain other countries, the financial crisis of 1997 gave specific endurement to the legislators or the stakeholders of that time, and they lead towards to tackle financial crisis. In that scenario, they have implemented workout Asia, Thailand, India, Malaysia, or the Malaysia is the most prominent country, or we can say it is the leading jurisdiction in which the workouts are carried on. In 1998, Bank of Negara, Malaysia, the central bank has established a corporate debt restructuring committee (CDRC), which creates a trustworthy impression among the society and resolve 57% of the listed company issues relating to the insolvency and other stakes, by which this phenomena or this lesson may be learned by the northern counterparts or northern states also, to make efficient insolvency mechanism in their locations. Another out of court procedure existing in the Philippines, where the approval under a court supervised reorganization procedure is recognized by Philippines law, or we can say a hybrid model or hybrid procedure of insolvency at that moment. Thailand is one of the countries that first intends identified this problem and solutions to incentivize the workouts, and which is known as Bangkok rules, or I can connect it with the London approach, incentivize, where the out of court settlements are recognized by the bodies, and tie up of the process. Two more important things I would like to give. One is Uruguay, the quick intention of insolvency process under that is also required. Colombia is also a very prominent place in southern globe, which creates an IT enabled and very fast speedy process of insolvency resolutions. Technologically, if we can find the development in global south, then ex ante AI models or insolvency models, in which Colombia, India, and China is the prominent stakeholders. And when we go to global south, we don't have to concentrate on India and China, the big icons of insolvency resolutions in global south. I would like to highlight the Russian impact or Russian concern towards the insolvency law. As an academician, I am concerned with the context of Russia. I use it for golden mean. It is at par with the benefit of the creditors and the debtors also, and it promotes the arbitration courts in their own uh, community. Globally, Russia, India, and China are not following the unilateral provisions. They create autonomous processes, or we can say the in-house processes to meet out the relevance of their own localities. We can say that only observing and following a path observed by one country is not good for others too. So we have to understand the relevance of our own culture, legal setups, society, and legal norms and business environments. As Asian region contains family businesses in a great number, so the model adopted by US or some other UK or European states is not at par with the adaptability or adaptations from the Asian or South or the global South. So, in conclusion, I just want to say that in this present scenario, global South and the global North have a bilateral learning process, or in a state of bilateral learning. If we go through the good aspects or the procedural beneficial provisions of US, UK, EU, German laws, and the Australia, Netherlands, and so many, or the developed Singapore is becoming a hub of debt resolutioning mechanism by adopting their model laws or by clubbing the insolvency procedures. And alongside India, China has presented a very good example before the world. So we have to learn by with each other and make a very wonderful insolvency environment, and which avoid the stigma towards the insolvent, and it is good for the business environment, and business is the backbone of any development or any development is the backbone of any nation or society. Thank you, thank you very much, Professor, for asking me to be here. Thank you, and once again, thanks for considering my request to be the time change. Thank you very much, sir.
Thank you very much. Thank you very much. And the next lecture is Dr. Muhammad Safdar Bhatti, expert the Islamic University of Bahawalpur, Pakistan. Be free to correct me if it was a misunderstanding. Thank you. I give you the word.
Yes, can you hear me?
Yes, yes, we can.
Okay, ji. Let me share my screen, please.
Can you try one more time?
Yes, just a minute. Okay, actually, I am unable to share it.
Yes.
Just
You
a minute.
can send the presentation in chat if you want. We can hear you, but we can't hear your presentation.
Okay, just a minute.
Yes, yes, the presentation is started. Okay.
Is it visible now?
Yes, yes.
Can you see my screen?
The screen, yes, but the presentation not started yet.
Okay. Thank you very much. And Bismillahirrahmanirrahim. Assalamu alaikum and a very good noon to everyone. This is Dr. Muhammad Safdar Bhatti from the Islamic University of Bahawalpur, Pakistan. And first of all, I would like to thank Dr. Igor and Dr. George and Dr. Delton for having me over here at this forum. And I'm very pleased to be connected with you people. And the topic of my today's talk is Navigating Pakistan Insolvency Framework, Challenges and Opportunities. And that is the brief sketch of my talk. Dear all, Pakistan's insolvency framework plays a crucial role in maintaining economic stability, ensuring creditor protection, and facilitating business recovery in times of financial distress. In Pakistan, insolvency mechanisms are shaped by a combination of corporate, banking, and individual debt laws designed to address situations where individuals or organizations are unable to meet their financial obligations. Navigating this framework requires an understanding of the legal structure, institutional responsibilities, procedural steps, and challenges that influence how insolvency cases are managed and resolved. If we talk about the research background, dear all, the legal foundation of Pakistan's insolvency regime primarily rests on statutes such as the Companies Act 2017 and the Provincial Insolvency Act 1920, alongside sector-specific regulations governing financial institutions. These laws provide mechanisms for liquidation, restructuring, rehabilitation, and settlement. Corporate insolving proceedings typically focus on protecting creditor rights while maximizing asset values and allowing distressed firms to recognize rather than dissolve. Liquidation involves the orderly winding up of a company's affairs as well. Why the reforms matters? My dear, a well-functioning insolvency system improves the ease of doing business and strengthens inventors' confidence by ensuring capital is allocated effectively, and unproductive firms exit in an orderly manner, and variable business are also rehabilitated rather than simply dissolved. Actually, I'm just going to give it a quick sign because of shortage of time. What is from liquidation to rescue? My dear, before 2017, Pakistan insolvency landscape was fragmented and inefficient. The Companies Ordinance 1984 and provincial insolvency laws were not designed for modern corporate complexity. They offered little room for restructuring, rehabilitation, or creditor negotiation as well. And these are some institutional frameworks you can gauge. And now I would like to brief you about some key features of the framework. The modern framework is designed to balance creditors and debtors while supporting economic stability and business continuity as well. Corporate restructuring mechanism allows distressed firms to reorganize debts and continue as going concerns, preserving employment, relationships, and value as well. Restructuring can include debt rescheduling, interest reduction, debt to equity conversion, and also operational changes to improve efficiency and reduce the cost. And where the system still breaks down. The first one is the specialized infrastructure is missing. Second one is the judicial proceedings are lengthy. Third one is the credit access is limited. And the last one is coordination and awareness remains weak. How the comparative lessons from the global framework. Basically, the US and the UK offer useful reference points. That was the chapter 12 in US is debtor friendly, while the companies keep operating, while the restructuring debts under court supervision as well. So these are some opportunities to reform. First one is to strengthen the regulation. Second one is the use out of court systems as well, and build capacity and expand credit support. These are some policy recommendations. Specialized insolvency courts and procedural simplification professional ecosystem, and the ADR and the stakeholder coordination must be done. Now, I would like to move towards its conclusion. Dear all, Pakistan's insolvency framework has transformed significantly with the Companies Act 2017 and the Insolvency Framework 2021, laying the groundwork for the more rescue-oriented and transparent system. These reforms support business continuity and the community to protect the stakeholders' interest as well. So before leaving, I would like to give you some suggestions and recommendations. Policymakers emphasize the need for reforms aimed at improving efficiency, strengthening instructional capacity, and aligning the insolvency framework with the international best practices. And these are some my suggestions from my side. And thanks for your patience, and any question, please. That's all, sir, from my side.
Yeah. Thank you very much. Thank you. It's a pleasure to us. The next lecture is Irfan Ullah Stanikzai, but I can't see him here. I write him, and I think he can connect us a little bit later. The next speaker is Fabio Farinella. Fabio Farinella, I can see him here. Hola, estimado Fabio, es profesor, director of CDIR, University of Mar del Plata, Argentina. He will talk about insolvency from an international perspective. We give you a word, estimado Fabio.
Okay, thank you very much. Thank you, Igor. Distinguished colleagues from Lomonosov Moscow State University, dear organizers of this youth forum, participants, friends. It's my pleasure to be here today, at least virtually, on behalf of our center in the University of Mar del Plata, Argentina. I want to begin by expressing my deepest gratitude to the organizing committee of this second youth forum on insolvency, and especially to our colleagues at the Law School of Lomonosov Moscow State University, Professors Svetlana Karelina and my friend Igor Kuznetsov. Thank you for inviting me to speak. This invitation reflects the long-standing academic cooperation and mutual respect between our institutions, and for that, we are very thankful. I also want to warmly welcome all the young researchers that in presence in other forums, professors and practitioners who have joined from all around the world, from Jordan, India, Pakistan, Afghanistan, Indonesia, Peru, Italy, Brazil, and many other countries. Your presence here is what makes this forum truly international. Today, on behalf of our center, I would like to share just 3 ideas that, in my view, highlight the profound relevance of this forum. The first one is about youth. This is a youth forum, and that is not merely a name, it's a kind of philosophy. But it's also an international forum, and that combination, I understand, is powerful. Youth represents the future, while internationality allows us to share legal cultures across borders. Too often, insolvency and bankruptcy law are seen as technical, even a kind of conservative field, reserved just for experienced practitioners. But the world is changing fast. We have new technologies, new business models, and new forms of debt that are emerging every day. It is the young generation who bring the fresh perspectives, the critical questions, and the creative energy needed to rethink old doctrines. And by bringing together young minds from dozens of countries, this forum creates a unique space where different legal traditions meet, learn from each other, and together build the future of insolvency law. I look at the program, I saw digital assets in Peruvian insolvency law, criminal liability for bankruptcy offenses in Brazil, trade secrets, intellectual property in corporate insolvency in India, the role of public prosecutors in bankruptcy proceedings. All these are not traditional topics. They are frontier issues. and they are being presented by distinguished professors and senior experts from each country. This is precisely what makes this forum valuable for young researchers. They get to learn directly from leading authorities, while at the same time having the opportunity to engage, to question, and eventually contribute their own fresh perspectives. The second idea is that the topic of insolvency has never been more relevant to the economic world. We live in a time of absolute uncertainty, post-pandemic debt, inflation, supply chain disruptions, and the rise of digital and intangible assets. In this context, insolvency law is no longer just about closing failed businesses. It's about rescue, restructuring, and resilience. A modern insolvency framework can save viable companies, protect jobs, and give honest entrepreneurs a second chance. It can also balance the rights of creditors with social equity, a challenge that many countries in our global south are facing right now, as we see in several presentations today. Moreover, the digital transformation forces us to ask new legal questions. How do we value intellectual property in bankruptcy? What happens to digital assets like cryptocurrencies? How do we handle cross-border insolvencies when companies operate globally? These questions are being explored here in this forum by researchers from different legal traditions. From our perspective in Argentina, we see insolvency law as an essential tool for economic stability and also growth. Our legal framework is primarily governed by the Insolvency and Bankruptcy Law, which has been in force since 1995, with several very important reforms in recent years. My country, Argentina, has historically faced economic volatility, high inflation, and recurring debt crisis. In this context, our insolvency system has developed a strong emphasis on judicial restructuring of corporate debt, what we call in Spanish concurso preventivo, which allows viable companies to renegotiate with creditors while continuing operations. We also have a specific liquidation procedure for non-viable businesses. One of our ongoing challenges is balancing creditor rights with social protection, especially for small and medium-sized enterprises and also workers, who are often the most affected by bankruptcy. In addition, cross-border insolvency is becoming increasingly relevant for my country, as more of our companies operate in expanded markets such as, for instance, the Mercosur, the market of the South, with Brazil, Paraguay, Uruguay, and other countries. Forums like this help us understand how different legal systems are adapting and what we can learn from each other. The third and last idea I want to share is that this forum is a brilliant example of international academic cooperation. Just look at the diversity of countries represented today. This is not a national conference, it's truly a global conversation. Cross-border insolvency is one of the most complex areas of international law. A company may be incorporated in one country, have assets in another, and creditors in a dozen more. When insolvency occurs, legal conflicts can become overwhelming. That is why instruments like the UNCITRAL model law on cross-border insolvency are so important, and why we need more comparative research. Today, we have presentations on international cooperations in cross-border insolvency, on recognition and enforcement on foreign proceedings, on BRICS comparative frameworks, and on piercing the corporate veil in Brazil and Russia. These contributions are invaluable. Our International Law Center at the University of Mar del Plata in Buenos Aires, Argentina, promoted comparative and international approaches to law. Our ongoing cooperation with Lomonosov Moscow State University is a testament to that commitment. I sincerely hope that this forum will strengthen our ties even further and inspire us to dream, maybe, of joining forces to carry out comparative projects among all the institutions represented today. Just concluding, let me thank the organizers once again, not only for inviting me and our center, but for creating such a rich, diverse, and forward-looking program. My special thanks go to the young researchers also who have surely prepared papers and presentations. Their work is the very heart of this forum. I wish everyone a very productive and inspiring work. Let us learn together, challenge together, and build a more just and resilient global economy, also together. Thank you very much.
Thank you very much, Professor Carlos Ferinella. And esperamos ver usted en otras conferencias. The next point I will give to the doctor, not the professor, Dr. Raul Nikam, professor of law, Sharda School of Law, Sharda University from India.
Yeah, thank you so much, Professor Igor, and long live to our partnership between India and Russia. Thank you so much. So today I am going to discuss, the comparative framework of, insolvency laws between the five countries that we called as the BRICS countries. And let's understand quickly that, how the comparative analysis that goes over here. So if we see basically there are five laws in the five countries. Brazil is having the bankruptcy and corporate recovery laws. Russia is having federal law on insolvency and bankruptcy. India is having Insolvency and Bankruptcy Code 2016. China is having enterprise bankruptcy law, and South Africa is having company law. Now, if you see the primary objective of these five laws in their respective countries, Brazil, it's talking about more focusing on the restructuring and preservation of the business. Russia is more, taking care of the structured, court supervised stages of the particular bankruptcy reference to the companies. India is focusing more on the time-bound corporate insolvency resolution process. China is focusing on the strong judicial supervision of the companies, and South Africa is focusing on the corporate rescue and protection of the employment. Now, when we go to the third main aspect, that is the procedural part, Brazil is having three stages. First one is the judicial reorganization, extrajudicial reorganization, and liquidation. As far as Russia is concerned, Russia follows the fourth stage. The first one is the supervision, then the financial rehabilitation. The third is the external administration, and fourth one is the liquidation. As far as India is concerned, India follow the corporate insolvency resolution process and liquidation. That is the two stages. As far as China is concerned, China follows three stages. That is the reorganization. If it doesn't happen, it goes for the compromise. If both the stages fail, then the liquidation is the last. And the South Africa goes for the business rescue and the liquidation. Now, as far as the decision-making authority is concerned, Brazil goes, a share between court and the creditor responsibility. Russia goes with the court control and the insolvency administrator. As far as India is concerned, India is purely going through with the creditor-driven committee of the creditors. China goes with the court, dominance procedure followed by administrator assistant. And in the South Africa, it goes with the business rescue practitioner with the court oversight. Now, as far as the court is concerned, the Brazil is heavily, supervised by the court. Similarly, Russia is also supervised by the court. As far as India is concerned, India is being supervised by the quasi-tribunal, that is the quasi-court authorities. China is again having a pure dominance of the high courts and the Supreme Courts, provincial court, and South Africa is also having court intervention as well. Now, when we go to the next aspect, as far as the creditors, who are the main source of the insolvency process and rescuing their credits, their role is very different in all the five BRICS countries. As far as Brazil is concerned, their participation is very strong through the committee of the creditors. In Russia, the creditors influence decision, but court dominates because the decision has to be approved by the Russian court. As far as India is concerned, Indian court follows the financial creditors' decision, which they have been taken in the resolution as in their own committee. As far as China is concerned, creditors' vote on the restructuring plan is important, but it has to get under the court supervision. And South Africa is concerned, their creditors' approval rescue plan is the final one. Now, as far as the rescue mechanism, area is concerned, Brazil goes with the judicial reorganization for the corporate restructuring. Russia goes for the financial rehabilitation and external administration. India goes with the resolution plan approved by the committee of the creditors. China goes with the Russian reorganization procedure under court supervision, and Africa goes with the business rescue proceeding. Now let's also understand the time, because this is very important, whether the timely resolution is been taken place for the company's revival, or whether company is not going to revive, then whether they are going for the liquidation, and whether creditors are getting their money back on time. So on this front, Brazil, the legal structure is flexible and it has not been defined any time limit. Similarly, Russia is also not mentioning any timeline. As far as India is concerned, there is a strict timeline that 180 days to 330 days, the decision has to reach to the conclusion and the final outcome should be there. As far as China is concerned and the South Africa is concerned, there is also no time limit. So it is here, it is only the India who is going very strict timeline procedure. Now, as far as the key institutional actors are concerned, in the Brazil, judges, administrator, and creditor committee plays the vital role. As far as Russia is concerned, arbitration courts and the insolvency arbitrator plays the role. As far as India is concerned, it is the NCLT, NCALT, and the resolution professional IBBI, and the committee of creditor plays the very vital role. In China, it is the People's Court and bankruptcy administrator plays the role. And in South Africa, it is the BRP, that is the business rescue practitioners they look after. Now, if you see, we are having one landmark case from each country. As far as Brazil is concerned, the landmark case law is IOSA judicial reorganization case. In Russia, we can have the Yukos Oil Company bankruptcy case. In India, it is the Swiss Ribbons Private Limited versus Union of India case. In China, it is the NA Group bankruptcy and the restructuring case. And in the South Africa, it is the Okendi Square Properties versus Farm Bosphorus Private Limited. Now, if we see the strength of all these 5 countries, insolvency legal structure is concerned, in Brazil, the strong creditor participation is been observed. In Russia, it is a structure multi-stage procedure in the 4 different stages is been promoted. As far as India is concerned, India is having very fast and creditor-driven resolution process. As far as China is concerned, it is the court control restructure of the large enterprises, and the South Africa focuses on the corporate survival and the job protection. Now, there are certain key challenges each BRICS country is facing. Brazil is facing the judicial delays. Russia is facing strong state influence in the strategic sectors. In India, it is the litigation delays in the court is facing, the problem. China, limited transparency in some cases because the Chinese government influence is very high. And in the South Africa, it is very difficult for rescuing the heavily indebted companies. So if you sum up this 5 country structure, so what we can say is that there are 3 different governance model is there in the BRICS country. The India follows the creditor-driven model. As far as China and Russia is concerned, they follow the court-driven model. And Brazil and South Africa, they are following the hybrid model. Now, if you see the comparative chart of all the 5 countries, we can say that all BRICS countries are increasingly shifting from liquidation to the corporate restructuring, meaning thereby reflecting modern insolvency policy trends. Example, Brazil is following judicial reorganization as the main vital legal model. As far as Russia is concerned, they are looking for the financial rehabilitation of the companies. As far as India is concerned, they look forward for the corporate insolvency resolution process, which is very strong and at par with the global standard. As far as China is concerned, they are looking for the reorganization proceedings, making more transparent and viable and speedily. And South Africa is looking for the business risk. Now, if we come, there are certain policy goals which are commonly required to be addressed by all the five countries through their legal reform and structure. So, what are those problems? First is the protecting creditors' right need to have work out very rigorously. The second important aspect that all five BRICS countries need to work out is how to preserve the economically viable businesses and the companies, not to allow them to go for the liquidation. Rather than they should survive. And how they should survive, that is the key area that all the five legal structure, countries need to find out. The third important point is maintaining financial stability of the company, whether it is small, medium, or conglomerate, or even a startup also. And the last one is that how the cross-border investment and entrepreneurship should be encouraged in between all the BRICS countries towards each other. So that's it from my side. Thank you so much for your patience, and thank you so much. That's it from my side. If any questions are there, the forum can ask. I am ready to answer that. Thank you so much.
Yes, thank you very much for your presentation. It was really comparative and very interesting.
Thank you. Thank you.
The next person, as you said at the start of the conference, it is Jorge Sactores Manrique, because he changed with Dr. Vivek Kumar. And he has a parallel event, and he will be in form of video. So I will give right to my colleague. I would like to know that Dr. Jorge Sactores Manrique always participate in our events, and it's a very good friend of our cátedra and of our events. Давай я попробую. Нет. Yeah. Dear Professor Jorge Sack, thank a lot for your presentation. And we have a next person. It is Irfan Ullah Stanikzai. Sorry if I don't get it right. It is a Vice Chancellor of Academic Research from Khan University, Afghanistan. I give you the word.
Thank you, doctor. Thank you, doctor and participant. Can you hear me? I'm audible.
Yes, yes.
I'm audible. Thank you. Thank you for your kind invitation and for the kind phone. Now, I would like to share the related presentations. Now it's visible.
No, no, not yet.
Presentation is visible.
Yes,
Now it's visible.
yes.
Yeah, thank you, doctor. Thank you, doctor, and participants regarding the youth forum. Now, I would like to talk and share the related the youth entrepreneurship and bankruptcy. As the main topics, I would like to talk about a little bit about the enterprise and bankruptcy. uh, Now we would like to know about the youth entrepreneurship and bankruptcy, rethinking the insolvency framework for the next generation of innovations. Here, there is a few terms like insolvency law, along with this startup policy, moreover the youth entrepreneurships nowadays. When we would like to know to graduate from higher studies, the most of youth are going to the entrepreneurship sides, like the are starting a small medium enterprise, which are huge contributions in the GDP of the countries. Along with this, we would like to know about the problem which the build for the wrong founder. Here, the bankruptcy law was written by the middle age of merchant with a creditor or mortgage and decide of accumulated obligations for the 23 years old, like with laptops with burn rate, the fate, the fall, and the consequences are savers. Here we know by the wrong subject, wrong skills, wrong peoples. If you would like to talk about the wrong subject here for the framework, predate the start of economy by our country, calibrates the consumer debt, not a founder equity for convertible notes. Here, on the other side, when we would like to know about the wrong skills here, I need a stage a company with poor employees faces the same formal machinery is a real chain with here, for example, a 20,000 accreditor, along with the other side is wrong people's. Here, the cost lend hardest on a first generation founders and young entrepreneurs whose financial reputation are still being built. Moreover, here the invisible wall around the risk takings. It's the main things when someone would like to initiate their business, if it's a small, if it's a large, but the initial stage is a risk takings. Here, the trees of a bankruptcy record shapes behavior before any failing or occurs. The stigma of a failure to a credit report, professional references in the entanglements of personal business liability forms, chilling effect of entrepreneurs' ambitions, felt most actually by those with the latest financial buffers. Generally, when we would like to know about general some examples like the data, the skills of the barriers, generally some starts in developing countries or underdeveloped countries. The most of if we know about the 90% startup failure rates, along with this the 65% founder under 30s. Moreover, when we would like to know about the 10 years credit impacts, here, if a startup failure rate of the startup fail within 10 years, like a founder under 30, side bankruptcy fear is a major barrier to starting or expanding a venture or business. Along with this, when we think in our talk for a 24-year-old who failed after the failing startup, they can't clear it at 34, full decade of compounding disadvantage during prime accumulations years. That's the main reason, that's the main things we should know about that. When we talked about the fresh starter here, when does it in actually fresh? Like here, we should know us, United States, Germany, or United Kingdom here's um, discharge liquids or credit reports for 10 years, like in Germany, after just 3 years of boards conducts, like United Kingdom, moved to 1 year's discharge in 2002. Along with this, here's some the economic cases like innovations require the freedom to fail. If you see in the picture here with the harvest failure penalties, in other picture you can see here's a fewer risks taken. Moreover, the fewer experiments, lower failure cost, more risk taking, more innovations outputs. Like for that, um, uh, there is some honest failure with a strategic abuse. If you would like to know or talk about here, any reform must distinguish between the founder and who fell in a good faith in the actors who use insolvency to escape involvement obligations. Here, a two tracks approach, generous discharge for a clearly identifiable, honest actors, as factors treatments for those who cannot demonstrate a good faith is theoretically a coherence if administratively demanding. Along with this, here is if we talk about the reform framework, there were three target interventions here: a scales procedure to entity size, a strengthened credit cover, persistence. Moreover, in a third stage, we should know the personal business liability frameworks. Along with this, here, if you see the legislative actions, a culture shifts in regulation guidance. Along with this, you can see a regulatory guidance. Moreover, when we know about the first failure is a date, not a verdict. Here's a talk about the goals, the risk, and the opportunities. Here, when we would like talk about those all things, about the risk,
Yeah.
about the risk opportunities. Before for that, when the entrepreneur would like to start or initiate their business, they should need to know about the pestle or pest analysis, like politicals, economical, social, and technological. They should do before some analysis. After that, they can do like in a politicals. What's the situation of the country or the region or the segments they would like to initiate the business. If it's okay, after that, the second stage is economicals. They should know both what is the purchasing power of the consumer or customer where they would like initiate their business or if there is any need of some financial help. Does the government can support them, or does the government give some subsidies for them? After that, we have another stage. It's technological. When they would like to initiate some business there, is there any competitor to have competitions with them? They have a good technology as compared to the new business. That is the main things. Along with this, the other is socials. Does the products or a service is the same to the certain culture, certain society or community? If it is not, then their business, if whether it's a service business, whether it's a product, it will be not going forward like before. In some examples like United States, like in German, like United Kingdom, we have seen for 10 years, for 2 years, for 3 years. Like for that, they should need all these things, that sort of analysis. If they have some needs for a financial support, for a human support, they should do this sort of analysis. After that, they will save their businesses. Along with this, they will protect for their businesses. Otherwise, if they do not do any sort of analysis like pest analysis, moreover, when they initiate their business, they should make some strategic goals for that. Along with the strategic goal, they should going according to their mission and visions. For that kind of strategic goals and achieves their vision and mission, they should make a KPI, key performance indicators, in a weekly wise, in a monthly wise, even though in a yearly wise, they should track their goals, their objectives, their tasks according to the given strategies. Like for that, they should make a SWOT analysis as well. What's their strength point? What's their weak point? And other side, what's the opportunity in the markets? And what's the threats in the market? Which is internal and external analysis. According to that, they are also set some strategy for that and track those strategies and those goals according to KPI, key performance indicator, to achieve their short-term, middle-term, and long-term goals. According to that goals, when they would like to achieve for 1 year, for 3 years, for 5 years, they can achieve their visions. For that, they will not face with the failures. That's the main things for the youth. Youth should know, and youth should consult with the certain mentor to reduce the risk, eliminate the risk. That's the main things. Thank you once again to give a times for that presentations. If you have any questions, you can do it regarding to this. If you have any questions. Dear participant, if you have any questions regarding to this, you can do it, your questions. If you have any questions, you can do it.
Yes, thank you very much. I have some problem with the internet. Can you hear me?
Yeah, thank you. The presentation is in. If you have any questions from the participant side, you can do it regarding to that. So that's why it's so interesting topics. Even though I have more than 10 years experience in that small and medium enterprise as well, and I have some research regarding to this. Even though before, according to this, I have visited to 2024 to a higher school of economics, Moscow, in one conference.
Very Thank you very much, and we will be in contact. I would like to present the next person is Julia Nordello Travessa, PhD student, University of Ituana, Brazil.
Thank you. I don't have any slides to present, so I'll speak fully from the text here.
Sorry, Dr. Irfan, can you cancel the presentation, the screen, please? Sorry, Dr. Irfan.
So I
Can
can
you stop
start?
the screen?
Yeah,
The screen. Thank you very
sure,
much.
sure. I have stopped this.
Yeah, Julia,
Thank
please.
you.
Okay, thank you. So first of all, I would like to thank you, Professor Deyuta and Professor Egor, for the invitation to speak in this seminar on the implications of Brazilian's bankrupt law for the claims of individuals that were contracted as legal entities. The focus of my remarks will therefore be on the classification of claims in judicial bankrupt procedures. It is essential to clarify that this is a classification that the law makes, aims to organize the order of payment. So given that, a company undergoing bankrupt does not obviously have sufficient assets to settle all its liabilities. So on focus on that, the federal law of 1101 of 2005 and its subsequent amendments in 2020 established that there are professional and extra concursal claims as the Article 84, and that after these are the settled, the liquidation procedures to claim admitted as concursal. Version on that, on the Article 83, prioritize legal settlement. The law of 1101 of 2005 from Brazil had the merit of establish at the statutory level the pursuit of satisfaction for those creditors demanded most preferential by the legal nature of of entities that have non-protection typicals. So, one moment. So, for example, by defining that waves owned by to the employees under the consolidation of labor laws of the bankrupt legal entity take priority from other payments, the other claimers that such as contractual penalties or other that isn't above the CLT laws, consolidated labor laws. However, the legislation was not updated to encompass the factual shift in the field of relationships established with other individuals, such as persons that were contracted by jurisdiction persons as such an employers. According to data from the Labor Court in 2024, alone, compared to 2023, there was a 55% increase in petitions seeking recognition of the so-called pejotização as a scheme to distinguish employment relationships. These figures are collaborated by a technical note published in 2025 by the Ministry of Labor and Employment, which indicates that from January 2022 to October 2024, approximately 4 million people who worked under the CLT laws, it's our labor laws regime, migrated to a legal entity arrangement like enterprise. The legal consequences have already begun to be felt. So including the jurisdictional knowledge about and the decisions. The Supreme Court has recognized the general repercussions of those social facts, which consolidates challenge from across the country against decisions rendered by the labor courts, recognizing employment relationships in case of fraud, like the pejotização. The scale of the expected impact will likely enter intensive the phenomenon of switching the individuals to legal entities contracts or discourage such contracts arrangements. Since the Supreme Court law will assess not only the jurisdiction of the labor courts to adjust those matters, but also what legal requirements would constitute a fraud. In addition to not contributing compulsionally to the public pension system, individuals contract as legal entities do not have any portions of their social security costs. Essential in cases of temporary work leave due to illness, accident, maternity, paternity, and so on, covered by those who hire the persons render services. As a result, in order to receive a monthly income upon retirement, each individual contracts as legal entity must enter into private pension agreements. So even though they receive monthly remunerations as payments for services rendered month by month, individuals' contracts as legal entities have none of the protections typically associated with a continuous employment relationship as labor laws. There is no regulation whatsoever regarding the discontinuation of these relationships, whatever grounds are required or not, or wherever termination is permissive, even in the situations of maternity leave, among others. This accelerated trend towards restriction contractual arrangements with individuals also direct affects the others in which such claims will be paid. If the relationships are formalized under the labor laws, they are paid first. If, on the other hand, they are structured toward individuals' entity laws, presenting themselves in the market as legal entity laws, they will be paid after all the creditors, all the claimants. Uh, Placing the claimants of individuals' contracts as legal entities in a position different from labor claims amounts to unjustified uh, discriminatory treatment of factual individual situations, which is prohibited by the principle of equality. It is in argument that there should be either a legislation amendment to express ensuring that engagements of individuals' operation as legal entities come to enjoy the same standing as those under the protection of labor laws, or the application of an expensive interpretation so that provision cover labor claims also applies to individuals contract as legal entities, who arrangements bear the hallmarks of employment relationships. This position that I defended here is justified not only by the principle of equality, but also by the individual fact nature that both situations share. Both carry a maintenance sustainability legal character and in continuous relationships remunerated by performance for work. So they should be treated as well. So I finished my presentation here and thank for uh, the time of speaking. Thank you.
Thank you very much for the interesting. And I would like to give the word to Semery Pereira Santos, also PhD student of University of Ituana. And the presentation topic is the role of the Brazilian Public Prosecutor's Office in bankruptcy proceedings.
Hello, dear colleagues. I would start acknowledging the invitation by Professor Steele to Brazil and Edward who's next up, and to give this concise presentation about the role of the prosecutor's office in insolvency proceedings in Brazil. You should praise the organizers of this event for their initiative. My name is Samuel Pereira Santos, and I am a PhD candidate at the Faculty of Law of the University of Itaúna, Brazil. Professionally, I am a public prosecutor in the state of Bahia, northeastern Brazil. And the Brazilian prosecutor's office has a different profile from most of other national institutions. It is not only responsible for criminal prosecution, but it also plays an important role in civil investigations and litigation. In business litigation, the main role of the prosecutor office lies in insolvency proceedings, especially those dealing with bankruptcy. In Brazilian business law, there are two institutions dealing with insolvency: recovery, which can be judicial or extrajudicial, and bankruptcy. And federal law number 11,101 from 2005 regulates both. It's important to note that only businesses can make use of this institute. During any of these proceedings, the prosecutor's office is called upon to intervene. Its role is to protect society's confidence in business legal institutions, be able to correct errors during the proceedings, and to investigate insolvency crimes or request the police to do so. Because of this role, during civil proceedings, the prosecutor's office may petition the judiciary to question creditors, request exclusion, reclassification, or ratification of credits, and replace the judicial administrator of the businesses that are the subject of this proceeding. It's also must be heard before the judge approves the deliberations of the creditors' assembly that usually ends any of these proceedings. Especially during the judicial recovery proceedings, the prosecutor's office must be notified when the proceedings are initiated and may appeal against this decision. In bankruptcy proceedings, when the business is already seen as impossible to be recovered, the role of the prosecutor's office is even more prominent. It must be notified when the proceedings are initiated, as it had been found during the recovery proceedings, but it may request information about the bankrupt business. It may file a revocation act against fraudulent tax performance by the debtor. It must be notified when assets are sold, and it must be heard before the proceedings are concluded. It holds many of the powers of a creditor, even though it doesn't occupy this position. The criminal prosecution of insolvency crimes is initiated by the prosecutor's office. If it fails to do so within the statutory period of 15 days, any creditor or the judicial administration may initiate. In conclusion, the Brazilian business insolvency proceedings are not merely a private matter. They are a matter of public interest in which the prosecutor's office plays an important role. And thank you for the opportunity to share a small portion of the Brazilian legal framework.
Thank you very much. And I would like to give the word to the next person. It's Dr. Ashima Jain, Assistant Professor, School of Law, Municipal University, Jaipur, India.
Yeah, hi, I've joined it. Am I audible?
Yes, yes.
Okay, hi. Thank you for this wonderful opportunity to speak into this youth forum. And I will be discussing on courts and corporate insolvency in India, specifically discussing some of the milestones with respect to that. So, India's corporate insolvency architecture under the IBC Code 2016 deliberately assigns courts or tribunals a high leverage, low intuition role, decisive at entry, admission, protection, moratorium, legality, plan approval, and forum control, but restrain on commercial merits, where the Committee of Creditors leads. They have been, with respect to India's model, they are fast gatekeeping, system-wide pause buttons are there. There is a legality-focused confirmation. They're approving plans if statutory requirements are met, while minimizing the merits review, price, or haircut. There is a strong jurisdictional center of gravity in India. Why the judicial energy, where the points where law must dominate, requires an appraisal, various sectors where the judiciary requires appraisal. So, for example, there is a moratorium which has been there under insolvency commencement date, which is being used by the code very properly. And courts are the central or control points with respect to the admission and gatekeeping of all the cases. Uh, I would like to also focus light on the various judicial achievements with respect to various case laws. Are number one, defining the moratorium's reach, and secondly, separating the corporate debtor shield from the guarantor enforcement. Courts treat a moratorium neither as a debtor holiday nor as a technicality. It is enforced as a core collective action device that makes IBC workable. Judicial role is as a supervisor of legality and not just a manager. The court intervenes when process integrity is threatened, where the conflicts of interest are there, procedural irregularities are there, and the statutory non-compliance are there, while leaving operational management with the RP and COC. That keeps judicial bandwidth focused on high impact disputes rather than day to day administration. With respect to more, if I like to give a light on, there is a Gujarat Urza case and Tata Consultancy's case and various other cases where judiciary has played a mind-boggling role. One of such another case is Mobilox Innovations versus Kirosa Software, where the Supreme Court has clarified that the existence of dispute, screening for operational creditor petitions, and the tribunal must reject insolvency if there is a genuine pre-existing dispute. Am I audible?
Yes,
Yeah, yeah,
yes. Thank you.
yeah. Okay. And at the last, I would only like to give a closing endorsement with my applause lines that India's courts and tribunals have done something immensely wonderful, and they have developed a jurisprudence that protects the process without hijacking the economics. The very balanced modern insolvency system has struggled to maintain. They have treated moratorium as a collective action engine, it neither toothless nor absolutist, and they have evolved a current doctrine on jurisdiction and interim relief that preserves going concern value while respecting legal boundaries. And most importantly, they have repeatedly affirmed a market compatible principle credit commercial judgment, which is belonging to creditors, and hence they have shaped the restructuring culture that is increasingly rules based, time conscious, and globally legible, while staying faithful to statutory design. Thank you. That is all from my side.
Yeah, thank you very much. Thank you very much for your presentation, for your time. And before I'd like to announce the next person is Dr. Ratna Sisodia, Associate Professor, School of Law, Renaissance University of India. The topic of her presentation is international cooperation in the cross-border insolvency, recognition and enforcement of foreign bankruptcy proceedings in India.
Good afternoon, everyone. Respected organizers, distinguished speakers, and participants. I would like to sincerely first thank Dr. Egar and the organizing team for having me here. It is a privilege to be a part of this international forum. I'm Dr. Ratna Sisodia, Associate Professor at Renaissance University, Indore, and today I'll be presenting on international cooperation in cross-border insolvency, recognition, and enforcement of foreign bankruptcy proceedings in India. So my focus will be on India's current framework, practical challenges, and the need for stronger international cooperation. So first we discuss what is cross-border insolvency. This kind of insolvency arises when a debtor has assets, creditors, or proceedings in more than one country. This raises key legal questions, that which court will have the jurisdiction, which law will apply, and how the foreign orders will be recognized. Unlike domestic insolvency, this requires balancing national sovereignty with global cooperation. Therefore, it is not merely a legal issue, it is a coordination and it is a challenge as well. So, why there is a need for international cooperation? International cooperation is crucial in these cases because without this, proceedings may be duplicated, cost will be increased, and the assets value will be reduced. And with cooperation, courts can coordinate, assets can be preserved, and creditors can be treated fairly. Thus, cooperation ensures efficiency, fairness, and predictability in insolvency resolution. Now, talking about the global framework, unilateral model, the most significant global framework is unilateral model law on cross-border insolvency 1997. It provides mechanism for recognition of foreign proceedings, access for foreign representation, coordination between courts, and a key concept is the center of main interest, COMI, which helps determine jurisdiction. Many countries like US, UK, and Singapore have adopted this, reflecting a global move towards harmonization. India's legal position here, when we talk about this sort of law, insolvency is governed by Insolvency and Bankruptcy Code 2016. While it is a major reform, it does not yet provide a comprehensive framework for cross-border insolvency, but there are certain two provisions which talk somewhere about this. Section 234 and 235 talking about bilateral agreements and letter of request. However, these are limited and not widely implemented. This creates a gap in handling international insolvency cases. So, recognition of foreign proceedings, India currently lacks a clear mechanism for recognizing foreign insolvency proceedings. Courts still rely on the Code of Civil Procedure and general principles of private international law. So here there is an example which could be taken, a case which is a key example, which that is Jet Airways insolvency case of 2019. The airline had assets in India and the Netherlands, leading to parallel proceedings. Initially, there was a conflict, but later the Indian tribunals allowed cooperation with the Dutch administrators. A cross-border protocol was developed, and in this case, it became a very significant rule that it demonstrated judicial innovation. It showed that cooperation is possible even without formal law. However, it also highlighted the urgent need for a structured legal framework. So, therefore, we really need something to practically be implemented in the countries and coordinate between different courts. So, if we talk about comparative perspective, countries like US, UK, Singapore have already implemented structured frameworks. They provide clarity in recognition, effective coordination, and predictable outcomes. India can draw from these experiences while adopting them in its own legal and economic context. And it is also valuable to reflect on comparative approach, including Russia. Russia's insolvency law provides structured procedures and strong judicial oversight through arbitration courts. India and Russia share common goals: creditors' protection, economic stability, and legal certainty. So, such platforms like this could play a crucial role in preserving and uplifting a more balanced law on this matter. So, concluding my point, cross border insolvency is a reality of global economy. India has made significant progress, but still requires first a structured, recognized framework. Second, a stronger international cooperation and a legislative reform. The future of insolvency law lies in cooperation, coordination, and trust between jurisdictions. Thank you so much, everyone. And I hope my presentation was clear. And if anybody have any question, I'll be happy to answer. And thank you so much, Dr. Eger, for having me here. Thank you.
Thank you very much for your presentation. I present this Dr. Valentina Williams, Professor, Head of Department of Management Studies, VVET from India. The topic is corporate governance and workforce management in insolvency. Raina Williams, we can see that you are here, but we can't hear you.
Am I audible now?
Yes, yes.
I think yeah. Thank you, Dr. Eger, and all the organizers for the opportunity. And my topic for today's session is corporate governance, since I come from a management background, corporate governance and workforce management in insolvency. So insolvency is not merely about financial failure. It is also a test of how responsibly a company is governed and how humanely it treats its workforce during times of crisis. So insolvency is we can call it as a critical phase in the life cycle of an enterprise. In jurisdictions like India, insolvency processes are governed by the Insolvency and Bankruptcy Code 2016, commonly known as the IBC. So this seeks to balance creditors' rights with stakeholder protection, which includes employees and workmen. So this is where corporate governance and workforce management becomes extremely significant. And my discussion today focuses on these factors. And to emphasize, I take two case studies pertaining to India to justify my objectives. So the first in the case is Jet Airways, and the second is Diwan Housing Finance Corporation Limited. So these two cases are the most significant landmark cases in Indian insolvency history, latest ones, which I have identified. Though they relate to insolvency, but they represent two different types of failures. So Jet Airways failure was due to operational and strategic management causes, and DHFL was due to the financial and governance causes. The Jet Airways, just a brief background. Jet Airways, which was once India's largest private airline, however, due to high debt, poor financial planning, and weak risk management, and more importantly, ineffective board oversight, the airline ceased operations in 2019, which affected more than 15,000 employees. And the main reason for its downfall is attributed to poor strategic management. So the founder held a very tight control, and even when the airline was failing, he reportedly blocked a potential investment from the Tata Group because he was unwilling to cede majority control. And the second reason was the passivity of the board. The independent directors were actually criticized for not challenging the aggressive debt-led expansion or the decision to acquire Air Sahara. So finally, it was revealed that the audit reported financial misreporting where funds were siphoned to related party transactions, and these transactions were not transparently disclosed to shareholders. And these actions affected the workforce largely. As I mentioned, nearly more than 15,000 direct staff lost their livelihood overnight. And the impact led to reported cases of depression and even a tragic suicide of a senior technician. So employees went months without salaries. The courts declared that the provident fund and gratuity are statutory dues and must be paid in full to employees. So while low cost carriers, that is Indigo and SpiceJet, they absorbed some of the staff. And the specialized full service culture of Jet Airways was basically largely lost. And from the governance perspective, we can observe that strategic decisions were delayed and the board failed to respond adequately to financial distress. In fact, the promoter driven control weakened the institutional governance totally. So, if you look at the situation from the workforce perspective, the employees went unpaid for months, benefits were withdrawn, and many employees had to approach courts and organize protests. And this reveals how governance failure can directly translate into workforce hardship because of this kind of a insolvency situation. So it was only in 2021, after prolonged delays, a resolution was finally approved. But unfortunately, employees' dues were significantly written down, re-employment was selective, and many skilled workers had already quit. Of course, this case has brought in its own precedent. It has become a precedent. The key lessons we can learn from this case study are delays in governance decisions worsen the situation. Secondly, resolution planning must be integral to workforce management. And most importantly, insolvency processes should focus on both economic efficiency and social impact. Now, coming to the second case, DHFL, that is Diwan Housing Finance Corporation Limited, which is India's largest housing finance company. This was the first time that a non-banking financial company was taken to insolvency by the Reserve Bank of India, RBI. So the investigation revealed that promoters of DHFL used over 70 shell companies to divert roughly around rupees 31,000 crore of public money into their personal real estate projects. Now, as we all know, shell companies are companies that exist mainly on paper and conduct hardly any actual business. But unlike this Jet Airways, where employees were seen as victims of a failing business model, the workforce of DHFL had to deal with the stigma, very sadly, had to deal with the stigma of working for a firm accused of a massive scam. And during the resolution process, thousands of employees faced job uncertainty as the company stopped new lending and they started focusing solely on the receivers, recoveries. Okay, and even the 100,000 plus fixed deposit holders, and many of them were retired senior citizens whose life savings were trapped. So the objective here is not just about human resource, but about board ethics. When the board fails at governance, as in DHFL, or remains too rigid, as in the Jet Airways case, the employees always pay the highest price because they are not the reason why this insolvency has happened. And when a company enters the zone of insolvency, a fundamental shift of duty occurs. Directors must and should prioritize the interest of creditors. In India, during the governance transition, control usually moves from the board of directors to an insolvency professional or the liquidator, official liquidator. And the responsibility of unearthing the hidden truth lies in the IP, that is the insolvency professional. Furthermore, governance must look towards the single goal, that is profit, to a multi goal, that is fairness framework. So this will ensure that secured creditors, unsecured suppliers, and employees, all of them get their legal due. The workforce and employees are usually the most vulnerable stakeholders. So high performing talent are the first to leave during a crisis, and management generally follow the key employee retention plans. However, the other staff are vulnerable. Therefore, Uncertainty will kill productivity. When they don't mention anything, the good workers, the talented ones, might leave earlier, leaving the company again, no chances of regrowing themselves. So, effective workforce management requires a radical transparency about the stay or go status to prevent a total collapse of operations. Another instance, very interesting instance, is of the Satyam scandal. Also, it's also called as the ghost workforce. It is one of the most famous example of a corporate governance failure in India. It is technically a fraud and a takeover case rather than a standard insolvency case. However, it is highly relevant because it laid the groundwork of how India handles workforce management during the corporate collapse. So the National Company Law Tribunal and the higher courts have essentially created a two-tier system for employees in India, and they distinguish between standard salary areas, which follow a specific order, okay, and the social security dues, which bypass the line entirely. So this new rule came into existence, and the most significant NCLT and Supreme Court rulings, notably the State Bank of India versus Mozaber Karamchari Union, have established that certain dues do not belong to the company's assets. So, as per Section 36, subsection 4 of the IBC, that's the Insolvency and Bankruptcy Code, these items are excluded from the liquidation assets, that is, a provident fund, pension fund, and the gratuity fund. The ruling, the NCLT Mumbai bench, confirmed by the Supreme Court in early 2023 for Jet Airways, ruled that the liquidator must pay these in full before even starting the waterfall distribution. Even if the company didn't actually maintain a separate fund, the liquidator is legally obliged to create or find the money from the assets to pay these first. So that is a wonderful um, hearing for us. And coming to the section 53 waterfall, the standard queue is like this. Insolvency resolution process, paid in full first. That is a fee for lawyers, the IPs, etc. The liquidators' fees, official liquidators' fees, etc. Then comes the workman dues and secured creditors, that is 24 months preceding the liquidation date. Then the employees, other than the workmen, 12 months preceding the liquidation date. Financial debts, which are unsecured, banks and bondholders without collateral, and government dues, that is 2 years preceding liquidation. And coming to the critical distinction from these rulings, that is differentiating between the workmen and employees, the NCLT relies on the Industrial Disputes Act 1947 to make this distinction. So workmen, generally those in operational, technical, or manual roles, they get 24 months of salary priority, and employees, these are managerial or administrative roles. So like, department heads, managers, and so on. And they are lower in the queue and only get 12 months of priority. The Jet Airways retirement dues precedent. In the Jet Airways case, the successful resolution applicant argued they shouldn't have to pay full PF and gratuity because it wasn't in their bid. The NCLAT and Supreme Court rejected this, stating, I quote, retirement benefits are a hard earned right and a social security measure. They cannot be subject to the commercial wisdom of the creditors. The DHFL and the social security charge. In the DHFL case, the ruling reinforced that while FD holders, fixed deposit holders, and creditors take haircuts, that is losses, the employee statutory dues, that is the PF and the gratuity, must be protected as a first charge on the assets, a principle reinforced by the new Social Security Code. So I conclude by saying that the Jet Airways ruling on PF and gratuity actually changed the math for future bidders in India. They now have to account for those employees' costs as non-negotiable liabilities. I read this somewhere, I'm just sharing. A company might be a balance sheet insolvent, but it should never be ethically insolvent. Protecting the workforce is not just a legal requirement, it is the only way to preserve the trust of the enterprise for its next phase. Insolvency is the ultimate test of a leader's character. Thank you for your patient listening. And thank you for the opportunity once again.
Thank you very much for your presentation. To be honest, dear colleagues, I do not see Dr. Shailja Vasudeva in the session, but I can see Dr. Raj Kumar Yadav has joined. Are you ready to proceed with your presentation? No. Okay. So the next person I would like to give the word is Salvatore Vitali, professor of international law, partner at Vitali and Partners from Italy. The topic of his presentation is interplay between international sanctions and insolvency law. I give you.
Okay, thank you very much for the introduction. Can you hear me, please?
Yes. Yes.
Okay, thank you very much for the introduction. And I have to say something that is, I'm a professor of international law of economics, which focuses on the international transfer of capitals, money, foreign investment. All of this has been destroyed, inclusive of my course, by the sanctions, because a new set of let's say, regulations which interfere with international investments, capital movements and transfer payments from one country to another, and so on, has been imposed, and these conflicts, first of all, with my teaching, which I have to change to my university students, because we have a lot of new, let's say, regulations, which I will talk about them with you. And also because the international framework of investments is now really under a serious prejudice. I don't know if we will be able to recover. When I say we, I mean the world from this situation. Now, today we can talk, I will talk about a specific, let's say, field sector of law, which is insolvency. But I mean, the problem can arise with any set of laws, and we can discuss and see how the sanctions which hit Russia, the Russian Federation, but they are not only in force against Russia. A lot of countries in the world, you can remember Cuba, which is under sanctions since 1958, if I remember, and other countries all over the world. The sanctions now have a serious impact on insolvency procedures and insolvency proceedings on an international transnational basis, because the international public policy, or in French, ordre public, is now taking dominance on, for example, insolvency rules. I will describe in particular European sanctions, let's say European regulations providing for sanctions, and the UK English sanctions. I didn't want to, let's say, discuss here also the United States sanctions, because otherwise it would be too much in just my presentation. But anyway, I mean, they are very similar to the European sanctions in this case. Okay, now the first problem which arises when we apply, when we see how the European sanctions are applied, is that creditors who are from sanctioned countries, or in the list of sanctioned people or entities, cannot, creditors of an insolvent company cannot be paid. That is, all other creditors, if the insolvent company estate still has some good assets to be sold, to be liquidated, and some money to be taken from the sale of these assets, the other creditors receive a payment, while the creditors who are sanctioned do not receive anything. So this is a breach, an infringement of a rule which I'm from Rome in Italy, which comes from the Roman law. That is the same, let's say, treatment of all creditors in the case of a bankruptcy. Now, instead of applying the principle of same treatment, some creditors receive the money, other creditors do not receive anything. In the best case, according to these regulations, the money which should, after selling the assets of the bankrupt company, the money which should be paid on a pari passu, another Latin, let's say, words, that is the same treatment, to the creditors who are sanctioned, in the best case, are put in a, say, blocked account, and they remain there blocked, let's say, frozen, until in some jurisdiction, for example, in Italy, the trustee in bankruptcy is able to obtain a special license to pay those creditors. If such license is not obtained, the creditors is not paid. The creditors are not paid. In England or in the United Kingdom, sorry, because it's a larger country, say, United Kingdom, there is also this system of a license to authorize the payment to sanctioned, let's say, creditors, but the government can, let's say, revoke a license which may have already been granted to a creditor, to, sorry if I have to say it, to a Russian creditor, according to certain, let's say, exceptions which they have introduced in this law on the granting of licenses. We are talking about the creditors. Also, debtors can, let's say, have problems. Debtors who are subject to sanctions. Let me give you one example. There was a case a couple, 3 or 4 years ago, if I remember, of Sberbank, a Russian bank which owned a subsidiary, Sberbank Austria, which Sberbank Austria, because of the sanctions, saw the withdrawal while it was still possible, and later the freezing of bank deposits owned by Russian, let's say, sanctioned entities, companies, and people. And the European Central Bank intervened, stating that because of the withdrawal of so much money from the bank, from a Sberbank bank in Austria, the bank was in the situation which, according to the European Central Bank, it could fail. So this statement caused the bankruptcy of Sberbank, with the loss of money from, I mean, for a lot of creditors, but first of all, for the loss of the assets of Sberbank Austria, which was, let's say, forced to go into bankruptcy, into a bankruptcy procedure, not because of some wrong, let's say, activity by the board of directors of the bank, by the directors, managers of the bank, but only because the sanctions had caused the withdrawal of a lot of money from its deposits, and furthermore, because it was prohibited to the shareholders, Sberbank, the Russian bank, the main shareholder, maybe the sole shareholder of Sberbank Austria, to intervene and put funds into the Austrian subsidiary, into Sberbank, in order to avoid the bankruptcy. So as you can see, there are problems for the creditors and for the debtors because of these regulations. It is only that creditors and debtors are not, unfortunately. There is another class, let's say, of people who are under prejudice because of these sanctions rules, and they are the trustee in bankruptcy or liquidators of the companies which have these problems of having creditors subject to sanctions. And for a trustee, it can be very risky because there is now a new law. I mean, the regulation which prohibits, for example, me as a lawyer, to assist sanctioned Russian entities or individuals was issued in 2014. Then there have been other, let's say, regulations updating that regulation, but practically it says that me as a lawyer, I cannot give any legal advice to those sanctioned entities. And I can only represent them in court if they call me when they are before the judge. So I cannot give advice to avoid to go in front of the judge, to not, I don't know, create any criminal situation or civil, let's say, loss. But so I cannot advise before, but when they go before the judge, they can call me. And this is a problem for the trustees. Also, the trustees of an insolvent company can go, I mean, can be not sanctioned, punished if they do not handle the insolvency proceedings in a way as to protect, let's say, the sanctions. That is, if during these insolvency proceedings, the trustee in bankruptcy does not fully comply, fully means more than 100%, comply with the sanctions. For example, it allows the payment to a creditor, to a Russian creditor, without having a license from the government to pay to the, I don't know how it can be paid because of also the sanctions which prohibit the transfer of money abroad. But anyway, that is a problem. The trustee in bankruptcy now risks to go to jail. Also a lawyer, if I advise a Russian, let's say, sanctioned company or people. For example, in Italy, there is a new law now which if a trustee in bankruptcy, let's say, is wrong or voluntarily, let's say, disregarded the sanctions during insolvency proceedings, he can go to jail up to 6 years, which is crazy. I mean, so everybody is scared of being appointed as a trustee in bankruptcy because you don't know how to handle it. The lawyers cannot even assist the trustee if the trustee is suspected of having, let's say, some preference for a sanctioned creditor. You see which kind of problems can arise. Coming to the regulations, the European regulations which govern the sanctions, we have in particular two regulations. One is number 269 European Union regulation of 2014 with 20 following, let's say, amendments, which has established the list of sanctioned people and sanctioned entities, which is Annex 1 to this regulation. The people and the companies, entities, also government entities, which are in this list are sanctioned entities or people, and therefore cannot be, cannot receive the money if they are creditor in insolvency proceedings. We are talking about insolvency, so I do not want to expand the scope of my talking to other kind of business, let's say, transactions and so on. Then there is a regulation number 833, still of 2014, but again, let's say, amended and updated some 20 times until even very recently, a couple months ago, which targets and sanctions the entire Russian economy. And this is where there is also Article 5, which prohibits me, me as a lawyer, to provide any legal advice to Russian entities, which can be involved in some business transactions. And this prohibition is to lawyers, auditors, trustees in bankruptcy, any kind of auditing, tax, or legal services are prohibited. In fact, I lost my few, but very good Russian clients, which I had before these sanctions, let's say. And also this regulation number 833 is important for our purposes because Article 5 bis, recently amended, prohibits any transaction of Europeans, let's say, with the Central Bank of Russia, which which means that, as I was saying before, even if a creditor can be paid in Russia, I mean, it is prohibited to make any transfer to the Central Bank of Russia. It is not possible to convert or transfer euros or British pounds if we, let's say, remain in Europe. To a Russian, let's say, creditor or recipient, because we are prohibited to deal into any kind of, let's say, money transaction with the Central Bank of Russia. And here we see the conflict between the bankruptcy laws, which have regulated for, I would say, thousands of years since the time of the ancient Roman Empire, have duly and, let's say, quietly regulated the insolvency problems. Now they become, let's say, subject to the international sanctions. If any principle, any clauses of a bankruptcy law, insolvency law, conflicts with one of these regulations, and you can consider that only Europe has issued 20 regulations on the sanctions from 2014, sorry, until recently. So you have to check 1,000 pages of regulations to see if they change or make null any clause of an insolvency law. Anyway, insolvency law, unfortunately, must be disregarded or not applied if the sanction prevails.
You go to conclude. Yes, thank you very much. Can you conclude?
Sorry, bye-bye. I'm here if there is any question. Sorry, there is too much to talk about. Thank you for having listened to me.
Thank you very much. You have raised some very important issues, so it was really interesting to listen. And I would like to give the word to the next person. I apologize in advance if I mispronounce your name, but it's Dr. Raj Kumar Yadav, Assistant Professor, Department of Law of Central University of Punjab, India. The topic is trade secrets in corporate insolvency proceedings, violation dilemmas, license disputes, and cross-border complexity. I give you the word.
Thank you, sir, for giving me an opportunity to interact with you on this contemporary topic. Respected chair, distinguished delegates, and esteemed colleagues, a very good day to all of you. I'm Dr. Raj Kumar from Central University of Punjab. It is my privilege to present my paper titled Trade Secret in Corporate Insolvency Proceedings. In this talk, I have tried, in this lecture, I will try to explore a complex and often overlooked intersection in commercial law, where the principles governing insolvency collide with the delicate nature of trade secret protection. Objective of my talk is to highlight the legal tensions, practical challenges, and the need for reform in this evolving area. Trade secret also comes in intellectual property rights as well as in corporate law. and it is a very significant topic where researchers are working on it, and the central problem lies with the transparency and confidentiality. In the core of this discussion lies a fundamental structural conflict between transparency and confidentiality. Insolvency law is built upon the principle of disclosure, ensuring that all relevant financial and operational information is made available to maximize creditor recovery and maintain fairness in the resolution process. Opposite to this, trade secret derive their entire value from secrecy. In the modern knowledge economy, businesses rely heavily on intangible assets such as algorithms, formulas, customer database, their list, and proprietary processes. Unlike patents and trademarks, these are not registered or formally recognized through statutory certification, and their protection exists only so long as they remain undisclosed. This creates a situation where the very act of disclosure required in insolvency proceedings can destroy the economic value of trade secrets. Thus, the law is faced with the challenge of reconciling two fundamentally opposing objectives. Now we will discuss about the legal foundations of trade secrets. At the international level, trade secret protection is recognized under Article 39 of TRIPS agreement, which defines undisclosed information as protectable when it is secret, commercially valuable, and subject to reasonable steps to maintain its secrecy. This establishes a baseline for global legal systems. In India, however, there is no dedicated legislation specifically governing trade secrets. Instead, protection is derived from contract law, equitable doctrines, and the principle of breach of trust, confidence. Judicial decisions such as Saltman Engineers Company Limited versus Campbell Engineering Company Limited have laid down that confidential information shared under an obligation cannot be misused. This position has been consistently upheld in many Indian cases, including John Richard Brady versus Chemical Process Equipments Private Limited, American Express Bank Limited versus Priyapuri, and Emergent Genetics India Private Limited versus Shailendra Shivam. In contrast, Russia follows a statutory model through Federal Law number 98 FZ on commercial secrets, which mandates formal identification, restricted access systems, and documentation of confidential information. While India relies on judicial interpretations and flexibility, Russia provides statutory certainty. Despite these differences, both jurisdictions recognize secrecy as the essential element of trade secret protection. Now we will discuss about insolvency framework and confidentiality crisis. The tension becomes particularly acute and serious when trade secrets enter insolvency proceedings under the Insolvency and Bankruptcy Code 2016. The interim resolution professional are entrusted with managing the debtor's assets and preparing an information memorandum containing comprehensive financial and operational details. This memorandum inevitably includes sensitive business information, including trade secrets. However, the court does not provide adequate safeguards such as structured confidentiality protocols, restricted database data access systems, or mandatory non-disclosure agreements for resolution applicants. As a result, confidential information may be exposed to multiple bidders, including direct competitors. Furthermore, Section 238 of the Code gives its overriding effect over other laws and agreements which may weaken existing confidentiality obligations. A similar lack of integration is visible in Russia's insolvency regime, where disclosure requirements exist without sufficient alignment with commercial secrecy laws, thereby increasing the risk of unintended exposure. Now we will discuss about valuation dilemma and the secrecy paradox. One of the most challenging aspects of dealing with the trade secrets in insolvency is their valuation. Trade secrets present a unique paradox. Accurate valuation requires disclosure of the underlying information, but such disclosure undermines or even eliminates their value. Traditional valuation methods are inadequate in this context. The income approach relies on projections based on confidential processes. The market approach is ineffective due to the absence of comparable public transactions, and the cost approach fails to capture the competitive advantage embedded in trade secrets. Additionally, trade secrets are often not reflected in financial statements and are not capitalized under the accounting standards, rendering them effectively invisible in distressed situations such as insolvency. This invisibility leads to systematic undervaluation. This contrasts sharply with assets like patents, which, due to their public nature, can be more easily valued and auctioned, as seen in the Nortel Networks case. Licensing disputes and legal instability. Now we will discuss about the same. Trade secret licenses introduce further complexity with insolvency proceedings. These licenses are typically treated as executory contracts which may be rejected during insolvency, thereby terminating the rights of licensees. The decision in Lubrizol Enterprises Inclusive versus Richmond Metal Finishers Inclusive highlighted this issue and led to the introduction of Section 365N in the US Bankruptcy Code, which provides protection to licensees. However, such safeguards are absent in India and Russia. This creates uncertainty, particularly in cases involving sublicenses or agreements containing non-assignment clauses. The rejection or disruption of such agreements can lead to businesses instability, loss of technological continuity, and a reduction in the overall value of the debtor's assets. Now we will discuss about cross-border insolvency and legal fragmentation. In an increasingly globalized economy, insolvency proceedings often have cross-border implications. The unilateral model law on cross-border insolvency seeks to facilitate cooperation and recognition between jurisdictions, but its implementation remains incomplete in countries like India and only partially aligned in Russia. This results in fragmentation with differing legal standards and enforcement mechanisms across jurisdictions. Conflicts may arise regarding the protection and disclosure of trade secrets, as illustrated in cases such as in Monda. Moreover, variations in international frameworks such as EU trade secrets directives and US laws, along with data protection recognitions like GDPR, further complicate matters. Once a trade secret is disclosed in one jurisdiction, it risks losing protection globally, making cross-border insolvency particularly challenging. Now we will discuss about structure problem, tangible versus intangible framework. At a broader level, the difficulty lies in the structural design of insolvency law itself. Traditionally, insolvency system were developed to deal with the tangible assets such as land, machinery, and inventory. Trade secrets, however, are intangible, secrecy dependent, and inherently difficult to quantify. This mismatch between legal framework and asset nature creates inefficiencies and exposes gaps in both protection and valuation mechanisms. Now, in last recommendations and legal reform, addressing these challenges requires targeted legal reform. In India, there is a need to enact a dedicated trade secret statute, written laws, and to amend the insolvency and bankruptcy code to include confidentiality safeguards such as secure data rooms, controlled access systems, and mandatory non-disclosure agreements. The development of specialized valuation standards for intangible assets is also essential. In Russia, reforms should focus on integrating commercial secrecy laws with insolvency provisions, introducing protections for licensees similar to those under US laws, and strengthening procedural safeguards. At the international level, a coordinated effort, including UNICITRAL and WIPO, could help establish uniform standards for confidentiality, cross-border protection, and continuity of licensing arrangements. Now I am concluding within minutes to include trade secrets represent assets of invisibility deriving their value from secrecy, while the insolvency law operates as a system grounded in transparency and disclosure. The challenge is not to choose between these two principles, but to harmonize them with a coherent legal framework. Achieving this balance will require doctrinal clarity, procedural innovation, and institutional coordination. Only through such efforts can legal systems effectively preserve and realize the value of trade secrets within insolvency proceedings. Thank you, Igor, for giving me an opportunity, and in future we will connect.
Thank you very much for your presentation. It was really interesting, and yes, of course, we will stay in contact.
Thank you.
The next person is Dr. Deepika Kulhari. Sorry for mispronouncing. Assistant professor of Jain Subodh Law College from India. The topic is digital economy transforming insolvency law in India. Can you hear me? We can see that you are here, but can you hear us? We can see you, but we can't hear you. Deepika Kulhari, yes?
Can you hear me now?
Yes, we can hear now.
Okay.
Yeah, you can start with your presentation.
Okay, I'll start with my presentation. So basically, I'll be talking about what are the challenges in Indian insolvency.
Sorry, but I would like to say that we have 10 minutes, and please go on this time, and better not reading. Thank you.
No issue, sir. I'll try to finish it in time. Thank you so much for having me on this platform, and I'll start with my presentation. So basically, I'll be talking about what are the challenges in our digital economy. And when we talk about our insolvency and bankruptcy code in India, it is just 10-year-old code. So it came in 2016. Though it came in the time where digital world was evolving, yet the code is being drafted in the kind of a pre-digital context. So basically, what happened was after insolvency and bankruptcy code, there are two things were the primary goal of this code. That was maximizing the value of the assets in case of insolvency and time-bound corporate insolvency resolution. So, providing a process which is time bound so that in any insolvency resolution, kind of a little less time is required. So, through this code, we definitely got a like a limitation on time period, and the resolution was provided on time. But one question still remains. So, in digital economy, data is considered a product as well as factor which is used by many companies in operating their businesses. So companies which work in fintech, e-commerce, social media, telecoms, they what they do is by selling data and information, they do their businesses. So they collect value from their ability to collect, process, and monetize data. So what is the issue in insolvency and bankruptcy code? So when we talk about assets which are given in the insolvency and bankruptcy code, it doesn't consider virtual digital asset as part of the assets. So that becomes a challenge in this digital era, and because there are a lot of things when you're not even dealing with any digital asset as a real asset. So that becomes an issue, because you are just talking about the assets which are physical, whereas the digital assets are liquid as well. So by saying that, I'm trying to say that data can be transferred borderlessly through other countries also. So that raises an issue. So complexity is further increased by interdependence between corporate value and data driven technologies, where customer data, algorithm, and digital infrastructure are critical component of insolvency status. Sometimes the data itself is a very big assets of a company, and if insolvency issue rises, then what would happen to those who are providing their money into this? What will happen to those creditors and those stakeholders? So the rise of a data centric business model has introduced a tension between asset maximization under insolvency law and privacy protection as well. So in India, though we have Digital Personal Data Protection Act of 2023, which just came 3 years back, it reflects India's commitment to the right-based data governance, and it is also recognized in our constitution right. So basically, the case of Justice K.S. Puthuswamy, Union of India, is the case which established that privacy was considered under the ambit of Article 21, right to life and personal liberty. So basically, under our constitution, right to privacy was given uh, uh, protection, and kind of a it is a constitutional right as of now. So later on, after the Digital Personal Data Protection Act came, it provided us by through few principles like consent-based data processing, purpose limitation, data fiduciary responsibility, and penalty for non-compliance. So in case there is any problem and data has not been protected, anybody's identification or liberty as such is being affected, so there are penalties which are given under Digital Personal Data Protection Act. So what happens in insolvency? So in insolvency proceeding, the personal data cannot be processed without consent, and data sharing must be limited to specific purpose, and data fiduciary must ensure security safeguards. But these requirements conflict with the insolvency board code, which emphasis on open data access for bidders. So then friction between these two legal regime becomes an issue. So during the corporate insolvency resolution process, where the resolution professionals are required to disclose their financial and operational information, to potential bidder. So that kind of data is open for all. So, in absence of any clear statutory framework governing data handling within our Insolvency Board Bankruptcy Code (IBC), further increase this issue and leaving insolvency professional in a position where compliance with one regime may result in breach of another. So also there are few cases, few judicial development in insolvency law which kind of prioritize economic consideration than talking about data protection. So in committee of creditor in SS Steel versus Satish Kumar Gupta, where Supreme Court said that there shall be very minimum judicial interference in the decision of committee of creditors. Then again, in Swiss Ribbon Private Limited versus Union of India, the court upheld that constitutional validity of IBC while stressing the importance of balancing the stakeholder interests. So basically, both the decision were in favor of creditors and only concentrating on economic consideration. So so that becomes a problem because we are not protecting data, we are not talking about our constitutional right. So the emerging discourse suggests that in future the insolvency law in India, there should be a harmonized economic objective with constitutional values as well. So data should be treated as a special category of asset that can solve this issue, requiring a tailored regulator safeguard rather than being and within a generic definition of intangible property or intangible asset. Proposed solution may include mandatory data classification and auditing during insolvency, where any personal data is required. So, the before disclosing that particular data, you can ask for consent from the people whose data is involved in that particular resolution proceeding. Additionally, a comparative insight from jurisdictions such as European Union and United States indicate a necessity of privacy safeguard within insolvency procedures, either through statutory provision or through institutional mechanism. We can solve this issue. In conclusion, I would like to say the digital economy has fundamentally altered the landscape of insolvency laws in India as well. And by transforming data into a central asset while subjecting it to into constitutional protection will provide a dual resolution for this problem. So both an economic resource and individual identification and data protection are of utmost importance. So that is it for my presentation. Thank you. Thank you for having me.
Thank you very much. The next speaker is Dr. Parharani. Sorry,
Dr. Barkha.
Yeah, is from University of Rajasthan from India. The main topic is accounting insolvency and fraud, the invisible architecture of financial collapse.
Yeah. Dr. Ego, with your permission, can I share my screen?
Yeah.
Thank you. Am I audible and my screen is visible?
Yes.
Okay, thank you very much. Good afternoon, everyone, and thank you for the opportunity to present. My topic, as you know, it's accounting, insolvency, and fraud, the invisible architecture of financial collapse. Insolvency, as we know, is often discussed as a legal or a financial event, but at its heart, it's an accounting story but that was ignored for too long. In these 10 minutes journey, I'll take you through 3 core ideas. First, how insolvency can be manufactured, not merely experienced. How accounting determines whether distress is real or engineered. And why forensic and technological innovations are now essential to detecting modern insolvency related fraud. The manipulation of insolvency is not new. In fact, creditors' protection against fraudulent conduct dates back to Roman law. through actio per which allowed reversal of transaction meant to defraud creditors. That same logic appears in medieval England, where even in 1376, fraudulent assets transfers were declared void. Today, this ancient principle lives on in Section 423 of UK Insolvency Act 1986, which allows court to set aside transactions made to put asset beyond the reach of the creditors. So despite 600 years of reform, the problem hasn't changed. Only the technological sophistication have. Insolvency has evolved from being a symptom of business failure to a strategic space where accounting, law, and structure intersect. In modern practices, insolvency isn't always genuine distress. It increasingly used strategically after prior manipulation to make business appear insolvent while continue elsewhere. Let's look briefly at how court have dealt with this. In the case Arbut, in the cases Arbut Leasing versus Havlet Leasing in 1990, the business was transferred. Just a second, let me have the cases. Yes. In the Arbut Leasing versus Havlet Leasing in 1990, the business was transferred to a related entity, stripping value and leaving debt behind. The court classified this as a fraudulent trading, a clear case of engineered insolvency. In the case L. Hasne versus Invest Bank PSC, latestly 2024 only, after a large judgment debts, assets were moved to family members through company controlled by a debtor. The Supreme Court ruled that Section 423 applies even to indirect transfers. It's the purpose and effect that matters, not the legal form. Third case, fourth, England Limited versus Harper, 2009. A debtor transferred asset to his wife to aid creditors. The court reaffirmed that even private or domestic transfers can be reversed if their dominant purpose was to prejudice creditors. Together, these cases shows a pattern. Insolvency framework meant to correct failures can be used to protect misconduct, turning insolvency into a mechanism of concealment rather than correction. Of course, not every pre-insolvency action is fraudulent. There are some cases where insolvency was genuine and technique was used properly, like these. Take Pro 4 Sports Limited 2015. The director transferred the business to an associate entity before liquidation, but only after independent valuation, creditors' consultation, and professional advice. The court found his action legitimate because his intent was to preserve value for creditors, not hide it. Second, contrast that buyers versus Samba Financial Group, where assets were moved cross-border into the jurisdiction that doesn't recognize trust. Even though the conduct was normally wrong, it was legally untouchable because ownership was extinguished under Saudi law. This shows that form can override fairness. This is very important. Form can override fairness. That's why Section 423 is not only sufficient to deal with the insolvency cases. So distinguish between genuine restructuring and engineered insolvency depends on three things. First is intent, second is transparency, and third is economic effect. All of these cases have one feasible common factor. See, only Section 423 cannot identify whether the intent was genuine or it is a transparent or not. And the technique we use to find out all these things is accounting. So all of these cases have one common common factor, accounting. Accounting is a decisive lens in insolvency determination. Legal framework, Section 423 ultimately depends on accounting evidences, on how value is recorded, transferred, and represented. Accounting shapes how court perceives economic substance, whether assets were transferred at an undervalue, whether value was extracted through dividends, or whether distress was fabricated. In Urbanart versus, as we saw the earlier cases, in Urbanart versus L. Hosni, forensic analysis of balance sheet revealed artificial weakening. In Pro 4 Sports, proper valuation validated honest intent. And in Buyers versus Samba, accounting exposed the economic reality even though the law could not act on it. So ultimate technique or evidence is through accounting. However, accounting is not just only sufficient. Insolvency is fought not just in courtrooms, but in spreadsheets. Accounting does not merely record failures, it defines whether failure is real or engineered. But here lies a serious gap. Traditional accounting is built on accuracy and compliance, not on intent or motive. A company may comply with every reporting standards while still structuring transactions to distort reality. For example, value extraction before insolvency, deferred consideration, or intra-group asset movement may all look legitimate on a paper yet conceal strategic weakening. That's why there is a requirement of a new type of accounting, that is forensic accounting. Forensic accounting plays a new role because traditional accounting leads us to just recording of a transaction or finding evidences. But this new type of accounting helps us to identify the intent also, because to determine the insolvency is real or engineered, we need to find the intent. As we saw in the previous cases also, in some cases where opinion was not taken, that cases becomes illegitimate, and after taking a proper opinion, the same cases becomes legitimate. So forensic accounting has become indispensable. Unlike ordinary accounting, it is investigative, preventive, and analytical. It's ask why a transaction occurred, not just whether it was recorded. Traditional forensic tools like ratio analysis, transactions, reconstructions, cash flows testings were vital in uncovering scandals like Enron and World.com. But fraud has outgrown spreadsheets. It now moves through digital platforms, crypto assets, and algorithm system that conceals value across borders and legal domain. To meet this challenge, forensic accounting is evolving into technological disciplines. Artificial intelligence and machine learning detects hidden patterns and collusive transactions long before collapse. Blockchain forensic allows crypto-based asset diversion in real time. Continuous auditing and real-time monitoring now flag early stage distress, catching last-minute asset transfers before insolvency filing. Graph and network expose concealed relationship among companies, directors, and offshore structures. Together, these emerging tools transform fraud detection from a reactive investigation to a proactive defense. To conclude, the story of insolvency is really the story of representation versus reality. Fraud evolves, so must detection. From Roman law to blockchain forensic, the struggle is the same between those who manipulate value and those who try to reveal it. If insolvency is a visible collapse, accounting is the invisible architecture beneath it. And the future of protecting creditors lies in ensuring that what is recorded on the books reflects the truth, not the illusion of a company's financial life. Thank you very much.
Yes, thank you very much. And now I can say that we start a new part of our conference, and we start with the participant from Brasilia, Loreana Hermenegildo de Oliveira. Sorry if I read it wrong. The topic is a criminal statute of limitations in bankruptcy crimes.
Thank you. I will share my screen.
Yes.
It's visible?
Yes, yes.
Good morning, everyone. Before I begin, I would like to express my sincere gratitude for the opportunity provided by esteemed Professor Dr. Lee from the University of Itaú. It's an honor to share this research with you today. The subject of my presentation is the statute of limitations in bankruptcy crimes. This debate is increasingly urgent because of the increasingly urgent given the current economic climate. In the year 2024, Brazil reached a historic peak in judicial reorganization requests, with 2,534 applications. This volume of cases requires a precise application of Law 11,101 of 2005 to ensure the integrity of the business environment. The current legal framework broke away from the model of the old decree law, 7,661 of 1945, where the limitation period was affixed 2 years and only began to run after the official closure of the bankruptcy. A rule consolidated by Summary 147 of the Supreme Federal Court. Under the current law, the statute of limitations follows the timeframes that set by the Penal Code. However, Article 182 established very specific starting points. The day of the bankruptcy decree, the granting of judicial reorganization, or the approval of an extrajudicial reorganization plan. The object of condition of punishment and just cause, the core of these discussions lies in Article 108. The judicial decision of bankruptcy or judicial recovery is considered an objective condition of punishment for these crimes. According to the legal theory explored in this study, this condition, combined with proof of the crime and authorship, constitutes the just cause of criminal action. Without this condition, the state is not authorized to investigate a specifically bankruptcy crime. This is a big discussion in law that attracts a lot of time. Some argue that it does not result in total impunity. The perpetrator can still be held responsible for common crimes, such as a fraud under Article 171, embezzlement under Article 168, money laundering, or crimes against the national financial system. Others believe that such effective accountability is impossible in order to preserve the legal assets protected by bankruptcy law. The law presents us with a significant interpretive challenge regarding crimes committed before the decree now as pre-bankruptcy crimes and those committed after now as post-bankruptcy crimes. For post-bankruptcy crimes, a literal application of Article 182 creates a paradox. If a crime, such as the embezzlement of assets, occurs 2 years after the decree, it could theoretically be considered prescribed before it was even committed. This interpretation violates the principles of reasonableness and proportionality, as the statute of limitations presupposes the passage of time after the fact, not before it. Another relevant procedural aspect occurs when a bankruptcy or reorganization decree is annulled by a final court decision. In this scenario, the objective condition of punishability disappears. Consequently, the criminal investigation or action must be dismissed, or in Portuguese, trancado, and argued due to a lack of just cause, thereby extinguishing the punishability of the bankruptcy crimes. To overcome this inconsistency, legal doctrine suggests two main alternatives. The first one, counting the limitation period from the moment the crime is committed, but suspending the time frame until the judicial decree occurs. The second, applying Article 182 strictly to crimes committed before the decree, while using the general rules of the Penal Code for any facts occurring afterward. I conclude by affirming that strengthening bankruptcy criminal justice depends on an interpretation that reconciles special norms with the fundamental principles of the penal system, ensuring legal certainty and effectively combating fraud with the insolvency system. So thank you for your attention.
Thank you very much for your presentation. It was very interesting and with good slides. The next person is Fernando Batista. It's a PhD student from University of Ituana, and their topic is control theory, criminal liability and bankruptcy offenses, insights from Brazilian law.
It's visible?
Yeah.
Good afternoon. Thank you for having me. My name is Fernando Marçal Soares Batista. I'm joining you from Brazil. And today I speak about control theory and the criminal liability in bankruptcy offense in science from Brazilian law. My presentation addresses a central problem in criminal law: who is truly responsible when crimes are committed through complex organizational structures. I will explore this question through bankruptcy offense under Brazilian law, apply the control theory of perpetration developed by Klaus Roxen. Bankruptcy offenses are really committed by a single individual act alone. They typically involve corporate structures with multiple layers of authority, formal administrations, silent partners, and hidden precision. They operate behind legal facades. This creates a fundamental question in criminal law. Should liability be attributed to the person who formally executed the act, or to the one who actually controlled it? Traditional concepts of authorship built around individual physical conduct struggle to answer this question. And the gap has real consequences. It's allow those who design and direct criminal schemes to escape responsibility while subordinates bear the legal burden. Under Brazilian law, the bankruptcy offenses are regulated by Law 11.101 for 2005, particularly Articles 168 to 178. This offense includes fraud against creditors, skirmish of assets, and account manipulation, all of which can cause serious harm to the economy system and to individual creditors. However, the statute does not resolve, at least not explicitly, the problem of authorship in complex corporation structures. It defines the conducts, but remains silent on how to attribution the when multiple actors are involved across different levels of a company. This silence is not merely a technical gap, it's a structural vulnerability that sophisticated actors exploit. Control theory, developed by Klaus Roxen, offers a response to this problem. According to this theory, a perpetrator is not a simple the person who physically performs the criminal act. The true perpetrator is the one who holds control over the execution of the office. Roxen identified three forms of this control. First, control of the act, the classic case of the individual who personally carries out the crime. Second, joint control, shared dominance among co-perpetrators who divide the execution of the common plan. And third, and most relevant here, control of the organization, where an individual at the top of structure apparatus directs the criminal activity without perform and act directly. This third forum is decisive for corporate and economic crimes. It allows crimes law to look past formal ties and signatures and reach the person who actually command the criminal conduct. Well, in the bankruptcy contest, this distinction becomes concrete. It is common to find nominal administrators, individual formally registered individuals, who in practice follow the instructions of hidden controllers. These controllers make the real decision, they order the diversion of assets, instruct the manipulation of accounts, or design the structure of fraudulent insolvency, but they live in a formal trace. Applied control theory leads to a different conclusion than a purely formal approach would reach. The real perpetrator is the individual who controls the company decision, not necessarily the one who sends the documents. This is particularly relevant in the case of fraud bankruptcy, strategic insolvency designed to harm creditors and system assent device. In these scenarios, the corporate structure it becomes an instrument for crime, and control theory allows for the treated person who operates the instrument as the true author of the offense. In conclusion, the bankruptcy offense demonstrates that criminal liability cannot rest solely on formal rules or physical acts. Control over the conduct and special control over the organizational apparatus must guide the attribution of criminal responsibility. The Brazilian experience illustrates how control theory, originally developed in the context of international and macro criminal law, can be extended to economic and corporate crime with equal precision and legitimacy. In criminal law, is to keep pace with complexity through each crime is now organized. Control theory is not merely a theory opinion, it's the practical necessity. It's my presentation, that's all. Thank you very much for your attention.
Thank you very much for the presentation. And I would like to give the word to the next person, Jose Enrique Rodriguez. Pardon, sorry if it is not right. PhD student, also from University of Iguana. The name of the topic is Purchasing the Corporate Will in Corporative Law, Brazil and Russia.
Good afternoon, esteemed scholars, ladies and gentlemen. My name is José Henrique Rodrigues. I'm a doctoral student in Fundamental Rights Protection at the University of Itaúna, Minas Gerais, Brazil. It's the first time that I present my research at an international conference and to such a esteemed audience. It's a privilege. I do not intend to exhaust this subject or to analyze it in great depth. So my object today is simply to present the main counters of the topic. Today, I'll present a comparison between Brazil and Russia about a legal doctrine called piercing the corporate view. This topic is especially important in case of corporate insolvency. In corporate law, companies have separate legal personality. This means the company is legally separate from its shareholders and managers. Because of this separation, normally the company is responsible for its all debts. However, in some situations, courts may ignore this separation and they may hold the people behind the company personally responsible for the company's debts. This system is called the piercing the corporate view. Historically, the concept emerged in common law system, especially in the United Kingdom and the United States, as a judicial response to the improper use of the corporate form. Different countries treat this matter in different ways. In this presentation, I'll compare Brazilian law and Russian law. I'll focus especially on 3 points. The first point is the historical evolution in Brazil and Russia. The second point is the legal foundations. And the last point, the doctrinal approaches. Now, the first point, the historical evolution in Brazil and Russia. At this stage, it's essential to present a historical overview of Brazilian doctrine. The concept of piercing the corporate view in Brazil did not originate from statutory law, but rather from legal doctrine and the judicial construction. Its early evolution was influenced by foreign legal systems, especially those of the United States and the European countries. The doctrine gained significance in the second half of the 20th century as corporate activity became more complex. Initially, courts applied the doctrine in a narrow manner, demanding clear evidence of fraud or abuse of rights. The doctrine was later incorporated into the Civil Code of 1002, especially in Article 50. The provision always disregard in case of abuse of deviation or purpose of confusion of assets. More recently, the system introduced in procedural innovations, especially through the Procedure Code of 2050, include the incident of disregard of legal personality, which ensures due process and right of defense. The incident of piercing the corporate view, providing 25th Code of Civil Procedure, represents an important procedural instrument aimed at ensuring the effectiveness of judicial protection. Its purpose is to allow the extension of the effects of certain obligations to the personal actions of partners or managers when legal conditions are met. It's a procedural incident, not a separation action, which means that it must be initiation with an ongoing proceeding. The incident may be initiation at all stages of the organized phase, during judgment enforcement, and also in execution proceedings. The initiation of the incident may be requested by a part of by the Public Prosecutor Office when it has standing to intervene. One of the main innovations of the 25th Code is the condition to observe contradictory proceedings ensures the affected part the right to be heard before the decision. Once the incident is initiation, the main proceeding shall be suspended, except when the request is made in the initial petition. During the incident, the production of evidence is ensured, allowing the demonstration of the conditions for piercing the corporate view. At the end, the judge will decide on the piercing and make stand the effects of the decision to the actions of partners or managers. Thus, the incident of piercing the corporate view represents an essential system to balance corporate patrimonial independence with the protection of creditors. The Brazilian model evolved into an organized system. This regard remains exceptional, but with clear legal conditions. The second point, the history evolution in Russia. To understand the Russian model, it's essential to analyze its historical evolution. The theory of the controlled person in Russian law is one of the most interesting and sophisticated aspects of liability in the context of corporate insolvency. This theory goes beyond the traditional piecing of the corporate view, proposing broader and more functional model. Russian does not base its doctrine on judicial proceedings, but rather on statutory evolution. In the 19th, there was a process of private conversation with low transparency and weak institutional control. Many companies were deliberately driven into insolvency to avoid obligations and defraud creditors. In response, systems were created to hold controlled persons accountable. In Russian law, this concept was mainly consolidated in insolvency legislation, especially after important reforms starting in 2017. Control is defined in a substantial way, even without a formal position, and a person may be held liable if they exert determinant influence. The Russian model became solid in creditors' protection. The doctrinal approach. Brazil adopts the major theory of view piercing. It's necessary to prove abuse legal personality with diverse or purpose and confusion of accents. The other side, Russian approach. Unlike other legal systems, Russian development an autonomous category of liability aimed at protecting creditors. Russia adopts a functional approach focused on the concept of controlling person, which may include shareholders, directors, and show managers. If they collaborate to insolvency, they may be held responsible. A controlled person is defined as any individual who exercises control or significant influence over the decision of the debtor company. In this context, what matters is not only formal position, but the real power of control. One of the central elements in the adopting of a material criterion based on factual reality. The identification of a controlled person is based on criteria created by legislation and case law. Among these criteria, the ability to influence decision and the use bidding instruction stand out. Economic advantage and factual behavior as a manager are also taken into account. Russian legislation also establishes legal presumptions that may reverse the burden of proof. Thus, the Russian model represents a modern evolution of corporate liability focused on real economic control and effects protection of creditors. Conclusion. View piercing is an essential instrument. Brazil and Russia present different legal philosophies. Brazil adopts a narrow approach, and Russia adopts a functional approach. Both seek to prevent abuse. Understand these models is fundamental. Thank you very much for your attention.
Thank you very much for these conferences. It was very. And the next person is, to be honest, I don't know how to pronounce it. It's Thais Fernanda Santos de Silva Vercosa.
Vercosa, exactly.
Vercosa.
Thank you.
If you
Thank
don't.
you. Good afternoon, everyone. I would like to thank you for the opportunity to participate. My name is Thais, and I'm a PhD student at the University of Taúna. My research addressed the legal characterization of credit cooperative claims with the framework of judicial reorganization. A credit cooperative is a financial institute formed by people who voluntarily united to provide financial service to these members. Unlike banks, Its goal it's not profit, but the collective benefit of the members. Judicial reorganization is a legal procedure that aims to help a company overcome financial distress. Its purpose is to preserve the business active jobs and the company social function. The debtor submits a reorganization plan, which must be approved by creditors in a meeting. Credit cooperative claims in a judicial reorganization and generally classified as unsecured unless backed by collateral or legal priority. They are subject to the reorganization plan and may undergo novation, extended terms, or discounts. However, this understanding has been involved as the Superior Court of Justice of Brasilia has been establishing the position that claims arising from cooperative acts are extra-concursal and, therefore, are not subject to the effects of judicial reorganization. Thank you very much.
Thank you very much for the presentation. The next lecture is Gisele Batista Leite. Was right?
Yes. Yes.
PhD student, University of Ituano, Brazil. What is bankruptcy and when does it become a crime?
Good afternoon, everyone. Good morning here. Before we begin, I will share a PowerPoint presentation with you.
Yeah, you could try it open. Yeah. We can see it.
It's okay?
Yes. Thank you.
Today, I will briefly explain what bankruptcy is in Brazil and when when it can become a crime. First, it's important to understand what bankruptcy means. In Brazil, bankruptcy is a legal process applied to a company that's no longer able to pay its debts. Instead of allowed disorder, the law requires a process to deal with this situation. The goal is to organize the payment of the credits in a fair and transparent way. Now, bankruptcy itself it's not a crime. It is illegal economic failure. Companies may fail to do the economic crisis and the other problems. However, bankruptcy can become a crime when there is fraud or bad faith. Brazilian law defines situations where accusations relate to bankruptcy, a crimes offenses. For example, it's a crime to raise assets to afford paying debts. It is also a crime to falsify accounts or simulate debts. Another examples, it's transferring assets to provide credits from using payments. In these cases, the persons may face criminal penalties, including fines or imprisonment. The key idea is simple. Bankruptcy is not illegal in Brazil, but fraud is. So, bankruptcy is a illegal solution for a financial failure, but it becomes a crime when there is a dishonesty. Thank you very much.
Yes, thank you. Thank you very much. The next two person, but I can't see them here, is Rafael Pereira and Pedro Costa. If they are here or not. Rafael Pereira and Pedro Costa. At this, we can't hear them. I think that they not connected. The next person is Milagros Alejandra Fonseca Robles. Sí, bien está aquí, ¿o no? Estimada Milagros.
Hi. Hi, good afternoon. Can you give me a second, please? I try to connect from my laptop.
Yes, of course.
Thank you.
Voy a presentar. Milagros is a PhD student of National University of San Marcos, Peru, and the name of her topic is labor claims in insolvent companies in Peru.
Hi, good afternoon. Can you hear me?
Yes, yes.
Okay, I will start. I have some problems with my material, but I think it's not necessary right now. So it's a pleasure to participate in this international forum to address issues of particular relevance in emergency economies such as Peru. I will talk about labor claims in insolvent companies. As we will see later, in Peru grants workers some of the stronger protection within its legal system, including at the constitutional level. However, when a company becomes insolvent, that protection faces very specific limits that are not always visible at first glance. Today, I will like to invite you to reflect on this tension between robust legal protection and real effectiveness, which in many cases provides insufficiency. So, the central problem is does the fact that law gives priority to labor claims truly guarantee that the worker will be paid? My answer is clearly, I think it's not necessarily. And this is because there is a gap between regulatory design and economy reality. The law can establish priority. It can determine who gets paid first, but it cannot create assets where none exist. Therefore, when a company is insolvent, the real problem it's not only legal, but also material. It's there are insufficient assets, even the most protective creditor may say they right frustrated. So to begin, we must first clearly understand what labor claims are. In Peru, this includes all debts that employer owns to the employee as a result of the employment relationship. This includes unpaid wage, social benefits such as several paid, bonus, and social security contributions. But beyond their content, what mattered its signature. Thus, we are not dealing with just any commercial debts. We are dealing with a debt of a system nature that is not that it's directly linked to livelihood of the employee and their family. For this result, a legislative degree number 856 grants them priority over any other obligation of the employer. In simple terms, we talk about that Peruvian law holds that before paying financial or commercial debts, the worker must be paid. And also it's important to say, give me a second, please. And also it's important to say that it's not only legal, but also constitutional. The Article 45 of the Constitution established that wages and social benefits take priority over any other obligation to the employer. This is extremely relevant because it elevates labor claims to a higher level within the legal system. This is not merely legislative politely, but a constitutional mandate. This principle it's elaborate open by legislative decree number 856 and by general insolvency law, which extend this priority to the realm of insolvency. Consequently, the Peruvian system provides comprehensive protection from constitutional to bankrupt law. So now, when a company becomes insolvent, we enter a bankruptcy system where the rule change. In liquidation proceedings, the law established a clear order of a payment. First, labor claims, then alimony, followed by secured creditors, then tax claim, and finally other creditors. This framework seeks to protect workers even in crisis scenarios. However, we must make a fundamental clarification here because the Brincom system doesn't warrant payment, but rather organize the distribution of scarce resources. That is establish how resources are distributed when they are insufficient. Therefore, even though workers come first, if the company assets are limited, payment will be part of even non-exist. And I think this is where the real problem begins. When we look at the reality in Peru, this limitation becomes evident. The data show the most companies in bankruptcy are in liquidations, and this is important because in practice, liquidations are usually insolvent companies with not capacity of recover and insufficient assets. For more, empirical students have found that insolvency is concentrated in sectors such as commerce, reflecting these are not isolated cases, but rather are security phenomenon. In this context, workers face paradoxical situation. They have the most protective claims to the system, yet then often fail to collect them in full. This demonstrates that legal priority on its own does not solve the problem. Also, another important point is that that situation had sparked a significant debate in legal doctrine. On the one hand, the protective stage arch, the labor claim must have absolutely priority due to the natural attainment of substance and their connection to human dignity. From this perspective, any limitations on the priority will weaken work protection. However, on the other hand, there is a critical stage to question that is referred to the super privilege of labor claims, something like that. And from an economic analysis to the law, it is argued to expensive priority can affect the credit system, as final creditors face great uncertainty regarding to recover or their loans. This can result in the higher interest rate of the resource accounts to final to miss this. Therefore, the debate is not only legal, but also economic, and it is about finding a balance between social protection and the efficiency of the system. One, I think, important in particular case, it's in Peru. The case law also reflects this complexity. The Supreme Court has recognized the labor claims once determined in bankruptcy proceeding might be subject to a segment. This is relevant because it shows that at that point the claim case to be solved at the personal right linked to the worked and inquires proper dimensions. In other words, the labor claim can enter to maker and can be transferred and can be value economically. And this highlights its due natural and it protects a right, but also an economy asset. And to conclude, I would like to return to the central idea that Peru has a system that strongly protects labor claim and including at a constitutional level. However, the real debate is not about the recognition of the right, but rather its ineffectiveness. In a context where liquidations are common and many companies lack sufficient assets, the major challenge is ensuring that this legal priority translate into an actually timely and sufficient payment. Ultimately, the challenge is not only to protect workers in theory, but to protect them in practice. So thank you very much for this opportunity.
Thank you very much for your presentation. I also would like to announce that tomorrow we will participate in the cátedra in the University of San Marcos in Peru. Also, I will participate with my topic in Spanish, and so I don't say goodbye also for near future. Thank you very much for your presentation. The next person is nombre por si haber leído incorrecto, Lucero Beatriz Novoa Llerena, law student from National University of San Marcos, Peru, with the topic Digital Assets in Insolvency Proceedings under Peruvian.
Good afternoon. Let me a second to share my screen, please.
Yes, you can try.
Yeah, you can see it perfectly.
Yes, yes.
Thank you. Good afternoon, distinguished professors and fellow participants. I'm very pleased to the opportunity to be here. Today, I will be discussing the role of crypto assets in insolvency proceedings under Peruvian law. Well, when we talk about integrating digital assets into a framework, we are not referring only to the regulations, but rather to a broader process of adapting the law to new technological realities. Phenomena such as AI, metaverse, virtual environments, are generating new forms of assets requiring our thinking of traditional asset categories. Digital assets are intangible goods represented in digital form that possess economic value and can therefore be subject to rights, transfer, and exploitation with the legal sphere. Despite the lacking physical symptoms, they form part of individuals' patrimony and may involve in legal relationships, including insolvency proceedings. This category encompasses various types of assets. Among them, crypto assets stand out based on blockchain such as Bitcoin or Ethereum, alongside others such as intellectual property assets, commercial digital assets, platform-based assets, or tokens. This diversity highlights the complexity of the phenomenon and the challenges it poses for legal treatment. In this framework, crypto assets occupy a central position, both due to their economic relevance and the risks they entail, which justify the need for regulation, especially for the protection of investors. This study focuses on crypto assets as they present the greatest challenges in insolvency proceedings. First of all, we have to know what it means. So, these assets operate on decentralized networks without the intervention of central authority and rely on cryptography to validate transactions. The transfer is carried out through wallets and recorded immutably on the network, ensuring security and traceability. So, with the development of distributed ledger technologies, crypto assets are becoming an increasingly dominant force in business and consequently in insolvency scenarios. In Peru, has grown steadily. So in 2025, surpassed 1 million users and positioning the country as a relevant emerging market in the region, ranking on the 32nd place. This scenario reinforces the need for an adequate framework that ensures legal certainty and effective creditor protections. Currently, Peruvian legal system does not have a comprehensive and specific regulation on crypto assets. In practice, they are treated as movable property based on the numerous purposes of the civil code. As a result, in insolvency proceedings, they are incorporated into an insolvency state and, in principle, subject to the rules applicable to traditional assets. However, this approach is insufficient to address their particular features. So, this is how we could notice an issue. This situation reveals a paradox. While the use of crypto assets has become widespread in the country, the legal system still lacks regulations, creating uncertainty and limiting the ability of the insolvency proceedings. So we have some limitations. The inadequacy of the current legal treatment is reflected in several aspects. First, we have to know clearly that the crypto assets have a different natures, as the control depends not on the physical possession, but on access to private keys without blockchain. This means that the ownership of control cannot be determined through traditional concept or possessions, complicating the classification without existing legal categories. Second, their identification and location are particularly complex. The pseudonymous nature of transaction prevents a direct link between assets and individuals, facilitating concealment and hindering their effective inclusion in the insolvency state. Third, their high volatility poses significant challenges for valuation. Unlike traditional assets, whose value can be estimated with relative stability, crypto assets may experience substantial fluctuation in short terms, directly affecting the determination of claims and their distribution among creditors. Additionally, custody prevents specific risks. The loss or inaccessibility of private keys may result in the definitive and irreversible loss of the assets, adding a layer of risks not present in traditional assets. So then, in the light of this limitation, it's necessary to develop a specific regulatory framework. First, the spread recognition of the crypto asset through a specific regulation. Establishing an autonomous legal framework will overcome the limitation of traditional categories and ensure a more appropriate treatment aligned with this nature. Second, mechanism for identification and mandatory disclosure should be introduced. Debtors should be required to disclose crypto assets, including wallets and exchange accounts, in order to prevent concealment and ensure the integrity of the insolvency state. Third, specific rules on custody and administration should be adopted. Given the control depends on private keys, so secure protocols must be implemented to allow insolvency administrators to access and manage this access without affecting their value. Fourth, develop evaluation criteria adapted to the specific digital assets. Taking into account volatility, liquidity, and data, flexible and mixed valuation methods should also be allowed. Furthermore, flexibility in determining the valuation date should be introduced, as rigid application of the insolvency opening date may lead to distortion due to the volatility. Overall, these measures will contribute to an efficient framework capable of addressing the challenges while ensuring creditor protections. In conclusion, the evolution in the digital economy and the growing adoption of crypto assets reflect a profound transformation in the way assets and legal relationships are understood. However, this evolution has not been accompanied, at least in the Peruvian case, by a corresponding regulatory development capable of mitigating its implications. The application of the traditional legal categories proved insufficient, generating uncertainty and affecting the efficiency of insolvency proceedings. In this context, valuation plays a central role. Whether in liquidation or restructuring, the proper valuation of assets is essential for creditor distribution and for assessing the viability of business recovery. Therefore, the development of of a specific framework is not merely an option, but a necessity. The challenge is not only to regulate crypto access, but to adapt to the law to a new economic reality, ensuring the insolvency themes continue to fulfill their fundamental purpose, preserving value and ensuring capable treatment of creditors in an increasingly digital world. That's it, and thank you very much for your attention.
Thank you very much. It was very interesting theme, and I would like to answer one question if you can answer it. If you don't mind. Can I?
Yeah, of course.
Yeah. Puedo preguntar en español porque español es mi primera lengua extranjera. Para mí sería mucho más fácil
Sí,
preguntar en
perfecto.
español. Aquí en Rusia hoy en día también discutimos mucho el problema de criptomonedas y todo eso relacionado en la económica de Rusia y también en insolvencia. Pero el problema es que después de el administrador concursal de recibir estas monedas, el problema es de vender, porque unos creditores dicen que no hay que vender ahora porque el precio ha bajado y como sabemos criptomonedas pueden bajar y subir en un tiempo muy, muy corto. Y debido a eso quería preguntar si hay algunos mecanismos especiales en Perú para realizar criptomonedas en el mejor tiempo o cómo se resuelva el problema de cuándo vender criptoactivos durante el procedimiento de insolvencia.
Sí, de hecho, todavía no existe una regulación específica al respecto y por cómo se está manejando en la manera práctica es a la fecha en que se declara ya iniciado el procedimiento de insolvencia. El procedimiento concursal, que aquí lo tratamos, al momento que se declara eso, entonces ahí sería la fecha de corte en la cual ya se estaría evaluando cuántos serían los criptoactivos para poder realizar esta venta o esta distribución.
Pero eso se regula a nivel de los jueces. Ellos dedican, no jueces en Perú, es administración especial, ¿sí? Un órgano administrativo que dedica si se puede vender ahora o no.
No, no hay una sanción especial todavía. De hecho, lo vemos por otra entidad que es por Indecopi, donde se ven los procedimientos de insolvencia. Pero es muy raro que llegue a un juez, ya que eso sería sobre todo por temas de deudas, ¿no? Sería demasiado largo y específico.
Y hay pocos casos cuando criptomonedas se realizan durante el procedimiento.
Sí, muy pocos
Aquí en
casos.
Rusia también tenemos pocos casos, pero el juez puede incluir esos concursos, pero casi siempre son casos cuando el deudor lo ha dado voluntariamente a la masa concursal. En otro modo es muy difícil de encontrarlos. Muchísimas gracias por las respuestas y por su intervención.
Muchísimas gracias.
And the next person is Brenda Diana Quiroga Espinosa, expert in panel and compliance, Studio Muniz, and the topic is crimes of insolvency or fraudulent bankruptcy.
Okay, thank you. Well, good afternoon, everyone. It is a true honor to participate in this forum on insolvency, new problems, and challenges. I sincerely thank the organizers for the invitation and for creating this space for academic dialogue, which undoubtedly contributes to rethinking the law from a critical and contemporary perspective. So I'm start. Allow me to begin with a central idea. Insolvency is not in itself a criminal law issue. It is an economic reality. Market economics function precisely because risk exists. And within that risk, insolvency is a legitimate possibility. Not every company that fails does so in a blameworthy manner. However, the scenario changes radically when insolvency ceases to be an economic consequence and becomes an strategic tool for fraud. That is where criminal law finds its justification. That breaking point is the offenses of bankruptcy, fraud, or fraudulent insolvency prohibited for in Article 209 of the Peruvian Criminal Code as a mechanism to protect against conduct that not only harms creditors but also erodes trust in the economic systems. This offense punishes the debtor or anyone acting on their behalf who, within the framework on insolvency or debt and restructuring proceedings, carries out acts to the detriment of creditors. If we reduce it to its essence, the criminal offense responds to a very clear idea. It is not insolvency that is punished, but is fraudulent manipulation. The typical conduct reflects precisely that logic, the consummation of assets, the simulations or of debts or losses, of the improper favoriting of certain creditors to the detriment of others. All of them share a structural element. The deliberate distortion for the debtor's asset is a context where those assets consist to common warranting of creditors. Now, one of the most relevant debates surrounding this offense concerns the protected legal interests. From a classic perspective, is it argued that is protected in the creditor's right to credit, that is their legitimate expectation of patrimonial satisfaction. Under this logic, criminal law operates as a warranting mechanism against or of fraudulent management. However, a more modern view, and I will argue, one more aligned with the complexity of today's economies, proposes that what is a protected in the credit system as an institutions, credit is not merely a sum of individual relationships and is a structural element of the market. When bankruptcy fraud occurs, it's not only harms a specific creditor, but also affects general trust in economic transactions. Therefore, the position that proposes a mixed protection is particularly compelling, and simultaneous protection of individual patrimonial interests and the functionality of the economic system. From a functional perspective, this latter approach seems to offer a better explanation for the rationale behind criminal intervention. From a doctrinal standpoint, this is a special offense. It can only be committed by those who hold a qualified position within insolvency proceedings. The debtor thus acting on their behalf or thus administering their assets in the context. This is not a minor deed. It means that the criminal wrongdoing lies to not only the result, but in the position of control over the affected assets. Furthermore, it is an offense that punishes acts of disloyal asset management within insolvency proceedings directly linked into the core categories of economic criminal law. If we examine the typical modalities, we can identify different ways in which the wrongdoing is materialized. One, the consult of assets with insolvency involves removing assets from the riches of creditors. Two, the simulation of debts or losses, which introduces legal fiction into the debtor's patrimony. And three, the improper favoriting of creditors, which breaks the principle of equality governing insolvency proceedings. This last aspect in particularly relevant is that insolvency systems are not only designed to repay debts, but to do so under rules of fairness and transparency. Altering those rules amounts to distorting the system itself. And from a technical standpoint, it is an also important to distinguish that a self-concealment constitutes a continuous offense, while the other modalities are instantaneous. This distinction is not merely theoretical, it has significant practical implications in criminal prosecutions. Now, let's use a shift analysis to the corporate step. A key question is, what happens with legal entities? Bankruptcy fraud is not included in the catalog of offense under law 30,424. Therefore, it does not generate direct administration liability under that regimen. However, this does not imply the absence of consequence. Peruvian law provides for ancillary consequences under Article 105 of the Criminal Code, which allows for the imposition of several measures on legal entities when the offense is committed with their organizational framework. And this is precisely here that the analysis takes on a contemporary dimensions. Also, the Supreme Court as clearly establishes that the liability of legal entities is linked to existences for an organizational defect. That is the absence of control mechanisms capable of preventing the commissions of the offense. At this point, compliance ceases to be an accessory element and becomes a structural factor. Even for offenses not formally included in the law, the existence of compliance programs can be decisive in reducing risk and preventing unlawful conduct and mitigation legal consequences. In other words, compliance responds not only to a normative logic but also to a criminal risk management logic. Allow me to conclude with three final reflections. The first, bankruptcy fraud should not be understood as a mere property offense, but as a manifestation of economic criminality that directly impacts trust in the system. And second, criminal law intervention must remain within the limits of the principle of ultima ratio. Not every insolvency irregularity should be criminalized, only those involving genuine fraud. And third, the most effective response to this risk is not exclusively punitive, but preventive. Strengthening a culture of compliance, implementing control mechanisms, and promoting corporate integrity are now essential elements for the sustainability of the economic system. Because ultimately, credit is not sustained by rules, but by trust. And without trust, there is no possibility market. Well, thank you for very, very much.
Yes, thank you very much. It was really interesting. Yes, and the next person, which I would like to apologize for all this delay, for all these changes. The next person is I don't know how to read it. Niyet Kurian, Associated Professor,
Dr. Neeta
School of
Kurian.
Law,
Yeah.
First University from India, and the name of our presentation is Corporate Rescue Mechanisms under the Insolvency and Bankruptcy Code of India, Issues and Challenges.
Thank you so much, first of all, for this opportunity. Good evening, everyone. It is indeed an honor and a privilege to present before this esteemed audience who are very, very enthusiastic about insolvency reforms all over the world. I would like to share my slides. Is it visible?
Yes, yes.
Yes, thank you so much. So I would be presenting on the corporate rescue mechanisms under the Insolvency and Bankruptcy Code of India, mainly focusing on the issues and challenges right now in India, which we are facing. A very brief idea about the previous insolvency provisions which we had in India, we had a fragmented piece of legislation. There was no one codified law in India. When you look at the Presidency Towns Insolvency Act and the older ones, the Provincial Insolvency Act, these legislations predominantly focused on individual insolvency, whereas Indian Companies Act and the Companies Act, the latest one, 2013 one, focused on corporate insolvencies. So even the names were used interchangeably, which the IBC brought in significantly changed. Another legislation, which is the Sikh Industrial Companies Act, was the only legislation we had in India wherein there was some revival or the restructuring provisions were mentioned. So there was this legislation which had given this provision for the corporate debtors to come forward. And once the sickness of the industries are identified, there was a mechanism from the government side to see that whether you can revive the companies. But that was not an effective legislation. And as far as the creditors' debt recovery is concerned, we had two legislations which we still have, which is the RDBFI Act and the SURFACI Act, which ensured that both the creditors, whether secured or the unsecured creditors, can recover their debts from a corporate or a company. But there were a lot of infrastructural issues related to this legislation, which is when we decided to bring in the IBC, which is the Insolvency and Bankruptcy Code of India, enacted in the year 2016. Now, very briefly, why we can say that this particular legislation enacted in 2016 is a game changer law for India is mainly because of the objectives, which are the legislative intent, which is connected with the objectives of the code. For the first time in India, this legislation brought in a time-bound process. Under this code, every single process under the IBC, whether it is the corporate insolvency resolution process or multiple processes which are outlined there in the code, every single process, there is a step-by-step time given. Another is it mainly focuses on the revival of companies. So there is right now under India, there is no direct mode of liquidation to the companies once they have committed a default in paying their creditors. It will always follow this format under the IBC, wherein initially a revival is attempted, and if that is failing within a time frame wherein the maximum time given is 330 days, then the company will go for a liquidation. We definitely also have voluntary liquidation process under IBC. And this code also have ensured that, or is the legislative intent is to ensure that there is balance in protecting the rights of all parties related to the insolvency. So when I'm talking about the parties in this insolvency, the reference is to definitely to the creditors as well as to the corporate or the company itself. Then for the first time in India, we have individual and corporate insolvencies codified, which was fragmented in multiple legislations previously under one code. And we also have brought in multiple forums. For example, we have for every company who is into a default and who want to look into an insolvency process, they can come under the CIRP process. Other than that, we have also tailored a single process for the MSMEs, very particularly called as a pre-pack model. And thirdly, we also have a fast track insolvency process. So this is envisaged with a view to see that there is a lot more faster processes, and any of these processes based on the size of the company, they can choose. Now, also for the first time, we have right now a regulator looking at the bankruptcy itself, who is the IBBI, Insolvency and Bankruptcy Board of India. Then we have also formulated insolvency professionals. Earlier in India, we never had a set of or a group of professionals who were not only having knowledge related to laws, but also the financial aspects of insolvency, which was very, very important and which was not identified in earlier legislations. So this was also a first time one. Then we have information utilities, which provide a very accurate amount of default and the documentations related to it so that those initial pre-litigations can be avoided. Then we have professional insolvency professional agencies and a tribunal itself set up for resolving all company matters. That is the NCLT, National Company Law Tribunal. The next slide, I will be focusing on the first process, which is the corporate rescue provisions under the IBC. There are three ways in which a CIRP can be tried by the companies, and this will be applicable for any company who has committed a default and who is unable to pay the creditors. So the first one under section 7 would be a creditor initiated process, wherein under the code for the first time we have also differentiated the creditors into not only secured, unsecured, but more importantly as financial creditors and operational creditors. The reference being wherever the company owes a financial debt, wherein the time value for money and all is looked at, we can call them as a financial, they are defined as financial creditors under section 5. And those whom the company owes an operational debt, for example, it would be taxes to the government, employees or the workers, their dues, or even the suppliers and the other industries who have been supplying materials, raw materials, etc. to the company, they are called as operational creditors. And also the company itself who is coming for a corporate rescue, they can voluntarily also bring in, once there is a default, even before the creditor comes, takes them to the IBC process, they can file an application and continue the insolvency resolution process. And very, very importantly, if this resolution does not materialize within the time frame, which is 330 days, then the company automatically goes into liquidation. So that's a process envisaged under CIRP. Now, the second one, as I've already highlighted, fast track insolvency is only for startup companies and smaller companies, and which is defined under the Companies Act. Then pre-pack insolvency resolution process is very clearly designated. Only right now we have rolled it to the MSMEs in India, and we also have a fresh start process for the individual insolvency, which is not covered under this presentation. Now, what's the difference between the main process, that is the CIRP, and the pre-pack process? Because these are two different processes. More importantly, the default amount, which is the third point here, which is 1 crore and above, is what the CIRP will be looking at. On the other hand, pre-packs, because it's a MSME related one, the default amount is 10 lakh and above, then the application can be moved under pre-packs. Now, another is the time frame. Because it is for larger companies, they have kept a wider window, which is 330 days maximum time. Even though the initial idea was 180, it has been postponed, it has been accelerated, or it can be extended to 280 and thereby 330 days. But for a pre-pack, the maximum time is much, much lesser. 120 days you can complete the process, is what the legislative intent is. Now, the role of the resolution professional or the insolvency professional is more played or significant under the CIRP. On the other hand, in pre-pack, it is limited. And CIRP always looks a bidding process wherein wherein a resolution plan, which is to revive the company, is submitted by the eligible resolution applicants, and which is approved by the committee of creditors, which is a very strong body under the CIRP, comprising of financial creditors. Then the bidding happens, and thereby the company is handed over to the new applicant or the new interested party. That is how the CIRP works. On the other hand, PPIRP, it is not a creditor-driven process. It is a debtor-driven process, wherein based on a pre-negotiated plan, they will do the resolution process. That is how the idea is. And the resolution plan is submitted by the corporate debtor itself. On the other hand, the CIRP, it is to the outsiders. Corporate debtor cannot be a resolution applicant. So there is a significant difference between these two. Another important point which I have outlined here is about the liquidation itself. Even though it's not a rescue mechanism, right now it's a lot more streamlined. Therefore, we can say that liquidations in India also, we try to see that it finishes within a time of 2 years as envisaged. But right now, the amendment has been brought in, and we are trying to finish it off within a period of 1 year to ensure that there is value maximization. And we also have a distribution asset distribution mentioned under, as per the classified under section 53, which we call it as a waterfall mechanism, where the first priority is given to secured financial creditors. Secured financial creditors in the Indian context means the bankers and the financial institutions who have given a loan to the company. And there are also unsecured financial creditors, which could be home buyers, who are also brought under after an amendment 2019 under the category of financial creditors. We also encourage voluntary liquidation based on a condition that the corporate can wind up its business, provided it is ready to pay 100% to all its creditors. So voluntary liquidation is based on not a default. It is based on the premise that the company need to be solvent at the time of winding up. So these are the processes which we have. Now, moving on to the issues and the challenges related to the code. basically in India, what we have seen is we have a lot of infrastructural issues related to implementation of the code, which is a wonderful piece of legislation. The first issue is the delay in admission of the application. Most of the time, what has been given is, even though under the code, there is a mandate of 14 days within which the adjudicating authority, which is the NCLT, will have to admit the application. We see that because of procedural delays, this getting extended, and thereby basically after the process a moratorium comes in, all of those aspects can be diluted, and that can significantly affect the recovery prospects for the creditors. Second is definitely the India being a very populated one, and there is a lot of litigation happening. The sufficient benches which are right now, I think in India we have only 18 plus benches which looks into this, whereas the commercial activities and insolvency of the companies are a lot more. The workload is very, very, very huge for these benches. Therefore, there is a delay. Then there is shortage of permanent staff. Most of them are contract-based staff. Therefore, that is also adding on to the delay. Then CIRP, even though the mandate is to complete it within 330 days, that we are finding it extremely difficult to follow this timeline. And this can be a very important aspect when it comes to value maximization for companies or for the creditors, because the more time it delays, the entire recovery aspect can be affected. Then we also have seen that unlike in other jurisdictions, maybe where there are bankruptcy experts who come as judges, in India we don't have that thing because there is lack of so many experts, and therefore what we have seen is out of the two bench, wherein one is a technical expert and another is a judicial expert, we see that basically these people may not be technical experts as far as a bankruptcy or an insolvency is concerned, because all judges are allowed to come in, all the civil judges. And there are definitely a few areas which has not been resolved. More importantly, group insolvency, we still don't have a framework. Cross-border insolvency, our two sections are very limited, which because we don't follow the model law or the UNCITRAL model law. And there has also been a lot of proposals with this idea we are mulling out right now is whether we can have even separate insolvency frameworks for different sectors, like the airline sector, the power sector and all. So other issues is definitely, even though the code does not mandate, there has been multiple interference by the higher courts. Then in India, CIRP is a creditor-driven process. And most of the cases, if you look at the judicial precedents, says that the committee of creditors have a very, very important role, and a lot of power is given to the committee of creditors, which is primarily consisting of the financial creditors. So we have seen in multiple cases that there is abuse of power by the committee of creditors, wherein resolution plans may not be approved. And this particular form is used for a debt recovery, which is not the objective of the code. Now, inordinate delay in decision making by the committee of creditors also pushes this to a liquidation, more liquidation of companies we are seeing. Time delays causing in value maximization, erosion, less recovery for creditors. That is why they were also finding it extremely difficult, because once the recovery is less, they would find they would be able to go for other recovery legislations rather than going for a beneficial one, or a one which is enhancing the rights of everyone or balancing the rights of everyone. For the creditors, it is very easy to proceed in a one-to-one legislation, wherein the problem is, there will be a lot of piecemeal litigation. So that is something which we are seeing. Balance is very, very less because it's more or less a creditor-driven process. And one group of operational creditors, there has been criticism against they are not given their dues. So these are some of the very prominent issues. And definitely, initially, there's been a lot of lack of awareness related to the working of the code. But we see that right now, because it has been rolled and it's almost 10 years, we see that there is a significant push even from the government and from everyone related to the economic development of the country. Therefore, there is a lot more awareness, and we see that most of these issues are to an extent resolved. So to conclude very quickly, this is an excellent code which has been drafted by the government of India in the year 2016 after a lot of studies done, and bringing this idea that revival of the companies should be the objective rather than recovery for the creditors, because we have other creditor recovery legislations also. So this is a very beneficial legislation, and it looks like a whole the entire parties who are associated with this, there should be a more holistic approach towards insolvencies, and that's the objective of this bringing in this wonderful piece of legislation. But having said that, some of these issues, unless we resolve it, we cannot see the results of this wonderful legislation. And that's also the reason why looking at the viability of what is happening or market driven legislation, we have consequently amended it. Even now when I'm speaking, there is one amendment 2026 March, which has been already proposed. And I hope to see that a lot of changes will be brought, and this would be very, very effective in terms of value maximization and revival of companies. That's all. Thank you so much.
Yes, thank you very much. It was really very interesting, and sorry a lot for the delay. One more time. We will still in contact because I think that we can organize even more interesting events. Also, I can see that the next Professor Dalton Ribeiro Brazil still have class, and we don't connect it yet, so we can start another time the video presentation of fourth sectors Manrique, because we received the information because the first ones that was without the voice. So I will try to make it.
It's a pleasure to greet you. I am Jorge Isaac Torres Manrique from Peru, President of the Prominentia Justitia Interdisciplinary School of Fundamental Rights. I am deeply grateful to the prestigious MB Lomonosov Moscow State University of Russia and to the Dr. Egor Kuznetsov. In principle, bankruptcy that the dispenser of finances is much more than a simple suspension of payments. It represents a turning point, a crucial moment when business models are making strategies are reevaluated. Its significance transcends the merely economic affected employees, investors, and society as a whole. The significance of bankruptcy lies in the ability to purge the systems, eliminating unsustainable practices and paving the way for innovation. However, every bankruptcy process brings with if new troubles and challenge, job uncertainty, loss of market confidence, and the need for complex restructuring are just a few of them. Addressing these challenges requires strategic visions, proactive management, transparency, effective communication, and the pursuit of creative solutions are key to mitigation the negative impact. With, from this perspective, bankruptcy becomes an opportunity to learning and transformation, laying the groundwork for a more resilient and sustainable future. For the reason, for this reason, this important second youth forum, Insolvency, Bankruptcy, New Troubles and Challenges, is almost relevance and significance. In this opportunity, we talk about the interdisciplinary analysis of the bankruptcy challenges and fundamental rights. In this sense, bankruptcy or insolvencies is much more than a simple declaration of inability and meet financial obligations. It represents a critical turning point in the lives of individual and business, triggering a cascade of legal, economic, social, and psychological consequences. A true understanding of this phenomenon requires moving beyond sector-specific perspectives and adopting an interdisciplinary approach. This analysis aims to unravel the complexities of bankruptcy by examining the challenge inherent in this process and crucial and deep interconnection with fundamental rights. For a legal perspective, bankruptcy is a regulated process designated to organize the distribution of assets among creditors and, in many cases, provide the pathway to restructuring or the second change. Economically, it acts as a mechanism for a Medicaid cleansing and resource allocation. However, these perspectives are incomplete without considering the sociological dimensions which analyze the impact to the social fabric and power dynamics, and the ethical dimensions with questions the fairness of the outcomes and individual and collective responsibility. Bankruptcy, far from being merely a financial event is a crucible where fundamental human rights are put to the test, dignity, property, household, work, and access to the justice are directly affected, poses significant challenge for legal systems and public police. This analysis will explore the historical evolution and bankruptcy, the conflicts and interests it raises, its social psychological implications and contemporary challenge, with the aim of fostering a more holistic and human understanding of insolvency. Then we have about the breakdown and economic dynamics. For an economic theory perspective, bankruptcy it's a necessary mechanism for a market efficiently. It's allowed inefficient economic and it's to exit of the market, freeing up capital and labor to be relocated to more productive sectors. It serves as a warning signal rewarding poor business decisions and discourage excessive risk takes. The ability and cost to credit are intrinsically linked to the perception of insolvency risks. However, a wave of bankruptcies, especially its occurs of the context of a system's crisis, can have devastating effects. For example, financial contagion. The bankruptcy of a financial institution can affect to the counterparties, creditors, suppliers, customers, triggering and change reactions. Then we have loss of jobs and human capital. Corporate bankruptcy often result in mass layoffs with high social and economic costs. Then we have the erosion of confidence. A wave of insolvencies can undermine confidence in a financial system and the economic as a whole, hindering investing and consumption. Then we have the legal dimension, conflicted rights and contemporary challenge. In this sense, we have first, property rights and credit protection. For creditors, bankruptcy represents the materialization of credit risks. Their property rights are affected because they cannot fully dispose of the funds over of them. The bankruptcy process aims to maximize recovery, but the reality in that in most bankruptcies, creditors do not recover their entire investments. Then, for example, order of priority of claims. The law establishes an order of payment. Claims against the state expenses of the bankruptcy process themselves and claims with a special priority generally take precedent over ordinary and subordinate claims. This heresy and constant search of disputes and litigation, which each creditor seeking to maximize its position. Then we have action for restitution of assets. In this context of bankruptcy, the trustee may bring legal actions to recover assets of rights that we improvidently remove from the debtor estate in the period prior to the declaration of insolvency actions for rescission the invalidity. Then we have fundamental rights of the debtor. Personal bankruptcy, it's an event that directly impacts an individual most intimate shape, and their fundamental rights require a perspective that goes beyond the financial balance sheet. First, we have, in principle, human dignity and the right to a fresh start. Then, the right to hosting and minimum standard of living. Then we have right to the work and freedom of enterprise. Then due process and access to justice. Then we have the contemporary legal challenge. In this sense, we have cross-border insolvencies. Economic globalization has increased the number of the cases where debtors and creditors operate in different jurisdictions. The lack of legal harmonization creates asset havens of debt havens, hindering the coordination and effectiveness of the proceeding. Initiatives such as the European Insolvency Regulation of the UNCITRAL principles seeks to address these situations, but challenges remain. Then we have the new digital assistant and debits, the emergence of cryptocurrencies, digital seats, and decentralized finances platforms raises unprecedented questions about how to evaluate, control, and liquidate these assets and bankruptcy proceeds. The viability and decentralized nature of many of these instruments in reality complicate the work of insolvency administrator. Then we have the sustainability and corporative bankruptcy, increasing the relation between in sustainability business practices, environmental, social, and the long-term risks and bankruptcy is being analyzed. The assessment for a company viability is a crisis must also consider this impact on sustainability. Then we have socioeconomic and ethical perspective, the human and social factor. Then we have the social impact of bankruptcy. Insolvencies affects not only the individual but also their family and the community. For example, family dynamics, inequality and vulnerability, the stigma and exclusion. In this sense, we have the ethical dimension of insolvencies. Bankruptcy confronts with the profound ethical questions. For example, responsibility and blame, distributed justice, or the right to fall. And then, after, we have the health and well-being. The psychological toll to the debit and bankruptcy is immense. Chronological stress, anxiety, depression, and even crucial social thoughts and well-documented realities among people facing insolvencies. The lack of adequate psychological support where bankruptcy proceeds it's a significant shortcoming. Many systems will prioritize financial consideration over human well-being. Then we have current and future challenge adapting insolvencies law to the 21st century. Then, in this sense, we have the globalization and regularity harmonization. The growing global economic interconnection calls for a more robust and coordinated cross-border insolvency frameworks. The lack of harmonization leads to regulatory arbitrage and hinders the protection of creditors and debtors in an international context. Then we have the financial innovation and technological challenge, the rise of cryptocurrencies, assets tokenization, and decentralized finances presents monumental challenge for the identification, valuation, seizure, and liquidation to assess in the bankruptcy cases. The violate, decentralized, and often anonymous nature of these assets requires new tools and regulated frameworks. Then we have the sustainability and corporate responsibility. The climate crisis of the growing demand for corporate social responsibility and bringing of influence assessments of business viability. Future bankruptcies may be more closing like to the business models that are unsustainability in the long term, both environmentally and socially. Then we have the stringently prevention and second change. In this sense, we have financial education, robust and accessible financial education programs starting an early age are crucial and poverty over independence. Then we have credit regulation, early warning mechanisms, just determine the second change. Conclusions, bankruptcy is a complex phenomenon that requires an interdisciplinary analysis and uncover on many phases the legal, economic, social, and ethical challenge. It poses demand regularity frameworks that are agile, up to date, and fundamentally human skilling and balance between its necessary protection of creditors' rights and the imperative safeguarding of the debitor dignity and fundamental rights in the central texts and any modern insolvency system. Current the trends point to the need of the great international cooperation, adaptation, and new technological and fundamental realities and renewed emphasis of prevention and second change, moving toward insolvency system that not only liquidate or restructure the debts but also facilitate rehabilitation. Social reintegration and learning from crisis is a primary objective for building fair, more resilient, and economically healthy societies, wielded for the respective bankruptcy cases to be a mere epilogue and becomes a potential prologue and new opportunities. Thank you very much for your attention.
We are very thankful to Dr. Jorge Torres Manrique, but it is not all. We have next speaker is Valeria Biteeva. It's a student of master in Moscow State University, and the topic of her presentation is the problem of license agreements in bankruptcy in Russia.
So, good evening, dear colleagues. Today I would like to tell you about the problems associated with licenses in bankruptcy. So, I would say that section 365A of the Bankruptcy Code say that a trustee or a debtor in possession cannot simply can decide what to do with most contracts during bankruptcy. And with court approval, they can keep a contract and continue it, or they can reject it. But this rule has some limits, and section 365C says that some contracts are special, and in these contracts, it is important who performs the contract. The other party agreed to work with the debtor, not with another person or company. So if the law protects that other party and this party doesn't agree, the trustee or debtor in possession cannot simply take out of the contract or transfer it to someone else. So, in simple words, bankruptcy law doesn't allow a new person to replace the debtor, especially when the identifier of the debtor is important. So, courts have used this rule for many different contracts, And this includes personal service contracts, employment agreements, contracts with the United States government, some franchise agreements, and intellectual property licenses. So, as I said before, Section 365C stops a trustee or a debtor in possession from assigning a contract without the other party's consent. But there is an important problem in the wording of the law. The text says assume or assign, not assume and assign. And this is important because it may mean something broader. At first, it seems that a trustee or debtor in possession cannot even assume the contract and continue to perform it, even if there is no plan to transfer the contract to a third party. So the main legal question is this: does Section 365C only stop the transfer of the contract to another person, or does it also stop the debtor from keeping the contract and performing it during bankruptcy? So this question, I believe, is very important in practice because many contracts depend on the identify of the party. So there are two main approaches to Section 365C. The first approach is called the hypothetical test. And under this view, the court asks a hypothetical question. Could the debtor assign the contract to a third party under non-bankruptcy law? If the answer is no, then the trustee or debtor in possession cannot assume or assign the contract. The second approach is called the actual test, and under this view, the rule applies only when the trustee or debtor in possession really wants to assign the contract to a third party. If there is no real plan to assign it, the debtor may still be able to assume the contract and continue to performing it. So I believe that the difference is clear. The USA Supreme Court also didn't solve this dispute, but it said that this issue is very important for bankruptcy courts and for businesses trying to recognize. And as I already mentioned, Section 365A allows the debtor to keep or reject most contracts in bankruptcy, but this Section 365C limits this rule for special contracts. I also explained that courts disagree about the meaning of this section, and some courts use the hypothetical test, and some courts use the actual test, and the main issue is whether the debtor can keep performing the contracts or whether this section only stops transfer to another party. So now I'll speak about a case about a patent license agreement in bankruptcy. And in 1911, Research Media Technologies signed a software license agreement with Crivella Holdings. And under this agreement, the debtor received worldwide perpetual and limit exclusive rights to use two software patents owned by Crivella. The agreement also had a rule about assignment, and it said that the contract couldn't be assigned without the written consent of the other party. But there was an exception. Assignment was allowed to a successor in interest or to a wholly owned subsidiary. In August 2024, some creditors of the debtor, including Crivella, filed an involuntary Chapter 11 case. So later, Crivella asked the court to lift the automatic stay and terminate the license agreement. And Crivella argued that the debtor had breached the agreement and that the agreement couldn't be assumed or assigned. But the bankruptcy court rejected, and the court said that there was no sufficient cause to lift the automatic stay. One important reason was that the assignment clause in the agreement allowed transfer to a party other than the debtor or debtor in possession. Crivella appealed to the district court, and it argued that the bankruptcy court made two mistakes. And first one is that it said that the agreement didn't allow assumption and assignment to a hypothetical third party. Second is it said that the agreement couldn't be assigned if it couldn't first be assumed. But the district court agreed with the bankruptcy court, and the district court explained that under federal patent law, patent licenses are usually not assignable unless the agreement clearly says that assignment is allowed. In this case, the agreement did clearly allow assignment to a successor in interest, but also the court also said that these words "successor in interest" are broad enough, and they can include an entity other than the debtor or the debtor in possession. So Crivella had to accept performance from such a successor. And this case is important, I believe, because it shows that the exact wording of patent license agreement matters very much in bankruptcy. And if the contract expressly allows assignment, the court may permit it even under the hypothetical test. So that's all. Thank you for your attention.
Thank you very much. It was a very interesting topic. And I would like to present my topic. It is AI and new technologies in insolvency proceedings in Russia. It will be not a theoretical topic, but also some review of the mechanism already existing in Russian Federation to somehow make the work of the lawyers in the bankruptcy area easy. I will speak from the perspective of the Russian Federation, where insolvency law already operates within a fairly developed digital ecosystem. This effectively creates forms of automated triage, even though the legislation has not yet explicitly regulated them. In Russia, the foundation of it all is the comprehensive digitalization of insolvency and judicial information. There is three popular governmental systems. The first one is Unified Archive of Arbitration Court Cases Files, is CAT Arbiter service in the electronic repository of all cases heard by arbitration court. It allows for online consultation of any commercial dispute, including the insolvency of companies or sole proprietors. Sorry, one technical issue. Sorry. Also, one more program is EFRSB, the Unified Federal Register of Insolvency Information, consolidates all legally relevant data on bankruptcy and restructuring proceedings and is recognized in the insolvency law itself as a federal information source. These two sources are not smart in and of themselves, but they provide perfect raw material for IE systems. They allow judges, bankruptcy trustees, creditors, banks, and legal providers to leverage massive amount of data on thousands of proceedings. In practice, services that perform automatic searches in CAD Arbiter, for example, or as a company, already being used to access the reliability of a potential daughter, reconstruct the litigation history, and detect patterns of problematic procedural behavior. The second pillar is the tax administration. Russian Federal Tax Services, FNS, in recent years, the FNS has developed big data analytics system that created a digital profile of the data. The most frequently cited example is Squad, the comprehensive debt management and administration system which gathers information on the debt's assets, liabilities, relationships, and transactions from multiple public and tax sources. Squad does not merely describe the situation, but suggests the most effective course of action for the state. Which collection measure is most likely to succeed, whether it is reasonable to propose a restructuring plan, when it makes sense to initiate insolvency proceedings, and at what point it is most productive to pursue subsidiary liability against directors and beneficial owners. This approach is complemented by next-generation systems such as AIS Налог 4, where the federal tax service openly states that it uses artificial intelligence to continuously monitor millions of taxpayers, detect deviations from the norm, and automatically classify risks. At the intersection of tax enforcement and insolvency, this monitoring functions as a pre-bankruptcy screening. The algorithm groups taxpayers according to their structural default risk and directs the administration toward restructuring enforcement measures or, as a last resort, the initiation of bankruptcy proceedings. At the same time, the finance promotes transparency in its asset realizations. A public marketplace, sometimes referred as the debtors' assets showcase, has been created, which aggregates information on the sale of assets in insolvency proceedings and make it available to any interested party. From an insolvency perspective, this also serves as a form of triage. The system helps identify, classify, and prioritize assets with created liquidity, facilitating their sale or even early negotiations with potential buyers. The third area of Russian expertise lies in private and sector-specific solutions, particularly for insolvency administrations and major creditors. For administrations, there is, for example, the Rafinat AI service, a platform that automates typically insolvency administration tasks, collecting data from CAD and the insolvency registry, generating standard documents, monitoring deadlines, and increasingly automated analysis of reports and problematic transactions. These types of tools perform an initial document screening. They identify which of debt's transactions may be contestable, which creditors are potentially connected, and where there is a higher probability of recovering assets for the benefits of estates. There is much more programs and much more technology, and there are a lot of risks of data protection and cybersecurity, but but we have the next speaker, and to be honest, it was such time of improvisation, because we have free 10 minutes. Professor Delton Rivera, we are very happy to see you, because we have some gap of 10 minutes. There is a 10 minutes improvisation from me about new technologies which are used in a Russian insolvency system. So we are very happy to see you. We would like to say you thank with help with all organization, and for your students. All the documents from them was very interesting. And first of all, I would like to give you the word with your topic, which called judicialization of corporate restructuring plans, the Brazilian experience under law number 11101 of 2005. Thank you very much.
Thank you, Dr. Egor, for your very kind words. And from University of Itaúna, and in the name of my students, it is a great pleasure to join your prestigious event to discuss so important issue. Thank you so much. Well, I have a screen to share.
Yeah, you can try because we give the right to everyone to share the screen.
Yes.
Yes,
And
thank you.
Is it visible?
Yes, yes.
Okay, thank you, Doctor. Well, my name, as said before, is Professor Deilton Ribeiro Brazil. I am a professor at the University of Itaúna in the southwest part of Brazil, in the state of Minas Gerais. And my topic today, it's about judicialization of corporate restructuring plans, the Brazilian experience under Law 11101 from 2005. Well, talking about the Brazilian restructuring framework, the corporate restructuring in Brazil is regulated by law number 11101 from 2005. And the statute governs judicial reorganization, extrajudicial reorganization, and bankruptcy. Its purpose is to preserve viable businesses and reorganize debt. And why restructuring plan matters? Well, it's important to highlight that the restructuring plan is the central instrument of judicial reorganization in Brazil. It sets out the debitor's strategy to overcome financial crisis. And it usually addresses for payment conditions, discounts, asset sales, corporate and operational adjustments. And the plan affects multiple and conflicting interests. And the disputes usually concern about legality, feasibility, fairness, equal treatment among creditors. Because of this, restructuring often moves from negotiation and to litigation. And now talking about creditors as a key decision makers. And I think it's very important because the BRICS is increasing day after day. The commercial relationships between the countries of the BRICS are increasing. And it's important for the foreigner creditors or investors to know about our law. And the same way for Brazil to know how it works in the legal system in Russia, in India, and in other countries of the BRICS. And in this matter, creditors vote on the restructuring plan. Voting takes place through legally defined classes. This gives creditors a central role in the restructuring process. And here it's the key point that I would like to highlight, because in the Brazilian legislation, in the Brazilian statute, creditors have a central role in the restructuring process. And the system seeks collective rather than unilateral solutions. That's the second key words that are very important. And also, the court as legal supervisor. The court oversees procedural regularity and legality, and the judge must ensure compliance with mandatory legal standards. A major issue is the scope of judicial review. And continue as the court as legal supervisor, the core question is whether courts should review only legal validity or also economic feasibility. That's the point. Well, so we have the core tension between autonomy versus control. Brazilian restructuring law is marked by tension between creditor autonomy and judicial control. And excessive intervention may weaken negotiation. And insufficient control may allow abusive or unlawful clauses. Well, so the crackdown and judicial review. In certain cases, the plan may be confirmed despite dissent from some creditor classes. This mechanism that we call crackdown avoids strategic blockage of viable restructuring. And at the same time, it increases the role of the local judiciary. Courts must verify strict compliance with legal requirements. So I would say that in Brazil, we have a hybrid model. The Brazilian model combines private bargaining, collective voting, and judicial supervision. And the judicialization is not an exception. It is a structural feature of the Brazilian restructuring system. And as for my final reflections, I would like to add that the Brazilian experience shows that judicialization is both necessary and problematic. It is necessary because courts protect legality, due process, I would say due process of law, and fairness among creditors. It is problematic when excessive intervention delays restructuring and reduces efficiency. The central challenge is to preserve a balanced model which consists strong judicial protection, effective creditor participation, and viable business recovery. And in the end, successful restructuring depends on combining legal certainty, economic feasibility, and institutional balance. So, many thanks. Большое спасибо. Очень приятно.
Thank you very much. I would like to ask you if can you wait 2-3 minutes? I will close the conference and can we talk a little bit?
Okay, to talk about a little bit. Yes. Well, as I said before.
No, Prophet, you don't understand. I would like to close and ask you to wait me to talk about our future.
Yes, now I understood. Excuse me, my friend. I understood.
Sorry, my
yes,
English is not.
Make the closing session, and we will talk later. Yes.
Yeah.
Thank you. Спасибо.
Thank you very much. Dear colleagues, thank you very much for this very rich session. Today we had a truly interesting discussion with a wide range of perspectives from different countries and legal systems. It was a great opportunity to exchange ideas and learn from each other. We highly appreciate your time, your presentation, and your active participation. We believe that today's discussion has created a strong basis for future academic and professional cooperation. Information regarding the possibility of publication will be shared in our common chat shortly. Thank you once again, and we look forward to see you at our future events. Thank you very much. Bye. But I need to stop the... and also